Trenton Police Department.
All right, raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings.
I do.
Wait a minute. Is this supposed to be mine?
Oh, I she said it was. We switched to the
I'm on the state docket.
state document.
Yeah, I know. So, okay, whatever. All right, I'm going to do it anyway. I'm sorry. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do.
Go ahead.
Your Honor, on May 1st, 2026, at approximately 9:45 p.m., Trenton PD officers were dispatched to 3376 Van Horn Road, apartment 272, in reference to a domestic assault. Officers arrived and spoke with the victim, identified as Maya Merrow. Merrow stated her ex-boyfriend, identified as the defendant, Dalton James Parrott, with whom she has a past dating relationship with. The defendant was going through the victim's cell phone and observed a text message that made him upset. And at some point, the defendant grabbed the victim by the throat, held her up against the wall for several seconds. The defendant then threw the victim to the couch and continued to choke the victim. The victim stated she never lost consciousness, but she could not breathe and did start to panic. The defendant did finally let her go, gathered his items, and left the apartment where she was able to call 911. The defendant was observed walking down Van Horn Road where he was stopped by Trenton police officers and subsequently arrested. We did take digital photographs of the victim's throat showing injuries, and the victim did go to the hospital on her own after being checked out by the Trenton Fire Department.
All right, so they used to date. This is her ex, right?
Yes.
Based on your sworn testimony, I find the crime of assault with intent to do great bodily harm less than murder by strangulation was committed. There's probable cause to believe the crime was committed by the defendant and unauthorized the issuance of the complaint and the warrant for the arrest of the defendant. All right. For your appearance.
P78413, DC Counsel representing Mr.
Sir, your name?
Dalton James Parrott, Your Honor.
All right. So for purposes of arraignment, how does he wish to proceed?
Your Honor, we'll waive formal reading, stand mute, ask the court to enter a not guilty plea.
Sir, you have the right to remain silent. You do not have to say anything. If you say something in or out of court, orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. And if you cannot afford one, you would be appointed one at public expense. Also, if you choose to submit to question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, Your Honor.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary examination, the people would have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, then the case would be dismissed and you would be discharged. Do you understand that?
Yes, Your Honor.
Probable cause conference will take place on May the 12th at 8:45. That will be in front of me. I'm not sure why they have Judge Hesson's name on this. And then May the 19th will be the preliminary exam at 10:15, both of which will be in front of me. What would you like to say regarding bond, counsel?
Your Honor, I would like to, I spoke to Mr. Parrott. Currently, he's working, doing, I believe he works for the College of, excuse me, I'm sorry. He's working at Benson Tower making wind turbine blades. He's been doing that for the past 6 months. It's a good paying job. He's also, prior to that, he was doing maintenance, doing overhead crane and vault manufacturing for a local company. He currently has friends and family, or friends in Toledo, which is where he plans to stay once it's released on bond. He has no open wants or warrants, and his criminal history is clean, at least for the past 10 years. And he has no failures to appear in court. Based on the nature of the charges, He understands how serious they are. When we would ask the court for a personal bond in his case, because among other things, the Trenton Police Department has not asked for a cash bond.
Sergeant Benars, do you have anything to say on bond? And I would like you to be a little more specific with regard to the injuries that they ascertained or observed on the victim.
The victim showed redness on her throat. They did go back the other night and take pictures, which I have not seen yet. That was a request of the prosecutor. I cannot speak to those because I have not seen the photographs yet.
What are you asking for bond-wise?
Yeah, I will leave that to the discretion of the court.
Listen very carefully, Mr. Parrott. I'm going to give you a personal bond, but you're to stay away from that victim. Do you understand me?
Yes, Your Honor.
$10,000 personal bond. You can leave the state to go to Ohio.
Okay, thank you.
Otherwise you cannot leave the state. You can only go to Michigan or Ohio. You cannot violate a law. You must appear in court as directed. I'm telling you, no contact with Maya Merrill. You cannot write, phone, see, text, email her, or communicate with her in any way. No assault, abusive, or intimidating behavior toward her. You're not to enter the property address at 3376 Van Horn Road, Apartment 272 in Trenton. No alcohol. Was there alcohol involved in this, Sergeant, or marijuana or illegal drugs?
That was not related to me. I don't know.
I'm going to go ahead and delete that. I'm not going to order that. No firearms, no dangerous weapons. You're not to purchase, possess, or consume any one of those. You are not to be within 2 miles of the victim, her residence, or place of employment. So I'm not going to order a GPS tether. I want you to be clear with me, I want to be clear with you, Mr. Parrott. If I ordered a GPS tether, you're going to be sitting in the county jail for 5 days until they can fit it. I'm not going to do that.
Thank you, Your Honor.
But I'm telling you, if you have any contact, you have somebody call somebody who calls somebody who calls somebody who calls her, you're going to be sitting in jail for a long time. Do we understand one another?
I understand, Your Honor. Thank you.
All right. So your court date will be on May the 12th at 8:45 and then May the 11th or May the 19th at 10:15. Okay.
I'm going to copy that from you guys, right? Okay.
Thank you. Thank you very much. Have a good day.
Thank you, Your Honor. You
Thank
too.
you, Sergeant. People against
Have a good-
Sluter. Drake Allen Sluter, 24B146556. Mr. Sluter, come on up here, state your name, counsel, your appearance.
Morning, Mayor. Peter Bernard.
Drake Allen Sluter.
MIDC counselor for Mr. Sluter.
He was supposed to be here on May the 4th for a show cause. He's had no prior technical violations. On June the 18th of 25, I placed him on probation under section 771.1 for a period of 9 months. And then I ordered that he reappear in person on, he appeared on March 4th. Yes, on March 4th of 26. He failed to appear on this warrant. There are 2 counts: failure to attend and complete two of 3 days on the court work program, and failure to pay fines and costs as ordered. How is he going to proceed on these?
Your Honor, I spoke to Mr. Sluter. He's going to plead guilty to both of the counts. I would also make note to the court, make note that he missed this hearing because he was actually in rehab at the time, in inpatient rehab.
All right, sir, if you plead guilty here, I do want you to understand that would be 2 technical violations. You haven't absconded for 60 days, I suppose, because you were picked up. No, I guess it is 60 days today. So your probation could be revoked. Let me think. April 57. Yeah, it's 61 days. Your probation could be revoked and you could be incarcerated on this for 90 days with your 771 status revoked and the conviction entered. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all of those rights, and we are not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. To the charge you failed to attend and complete 2 of 3 days on the court work program, how do you wish to plead?
Guilty, sir.
Did you fail to attend 2 of 3 days on the court work program?
Yes, because
I want to know if you failed to attend that, sir.
yes, I did.
And then as to count two, the charge you failed to pay your fines and costs as ordered. How do you plead?
Guilty.
You failed to pay your fines and costs as ordered.
Oh, yes.
Anybody force you to plead guilty?
No.
I'll accept your plea to both counts. Why wasn't he here? He was in rehab for how long?
Mr. Sluter, how long, when did you get released from rehab? Your hearing was on March 5th.
I was released from rehab in March, but I was also taken to Lake Ridge, where I was also placed in rehab there under their custody, which I just got released from there not long ago.
When?
About 2 weeks ago.
Why didn't you come in here?
I didn't. I was gonna come and take care of all this. I just
When?
like
Tomorrow, but right? You know how many people told me
Yes.
tomorrow?
yes,
You
sir.
can't do this, son.
I know.
Detective, can I have your name back there, please?
Detective Ronald Tar, Brownstown PD.
Do you live in Belleville, Mr. Sluter?
Yes, at the moment I do, but I'm trying to get back into another sober living.
Where was he picked up, Detective?
Your Honor, I'm not sure of that.
It was in Detroit.
He's a passenger in a car in Detroit. I believe he's been incarcerated since the weekend. Mr. Sluter, how long have you been in custody? Since Friday?
Since Friday, yeah.
Call in, Jessica. You got to take care of things, sir.
I understand.
I mean, it's great that you're going to sober living and all these other places, but you can't ignore your obligations. You could have gotten online from a facility, and that's number one. And number two, you should have shown up here the day of, and that's assuming you went, the day that you were released, and that's assuming you went. I don't have any proof that you went. Do you have any proof that you were there?
Yes, in my property, but I don't have any of my property with me.
This is not good. I need your name, please. So he was picked up. He says he was at inpatient facilities. Do we have any proof of that?
Yeah, he's been in and out of inpatient facilities pretty much the entire time I had him on probation. The last proof of him being inpatient I have was January 28th of 2026. They sent me a letter of sacred heart stated that he was inpatient at that time. I don't know if he was released or anything though. I never got a release report from it.
You know, you had other misses on this case too. You know that, right? You got to grow up.
I understand, sir. I'm sorry.
You don't have to apologize to me. And by the way, picked up another charge, right? When were you going to tell us about that? Whatever happened with that case out of Van Buren? Possession of meth.
I was supposed to, I went back to court and it was supposed to get dropped down to probation through them. But with me being in treatment, I never was able to go back to court.
So you didn't go there either, huh? You graduated, get the screening, the pre-sentence. Did you graduate?
Yes, I did.
Mr. Sluter,
Yes,
you're 23.
25.
Okay, I'm sorry. You were 23 at the time we did this, handled this case. You're not doing too good. You used up your quota of criminal convictions between now and the time that you're 98. Do you know that? I'm serious as a heart attack. It's time to grow up. You're living with your grandma, right?
At the moment, yeah.
But why are you living with your grandmother? Because you're not getting out, you're not working, right?
Yes, I've been
He
working.
doesn't,
Well, I'm just telling you. Shame on you. You're 25 and you're living with your grandmother.
Yes, sir.
Look, I don't have any choice as far as I'm concerned. I mean, he's coming up. There's no way he can do the court work program days. and pay his fines by June the 18th. I'm revoking your 771.1 status.
Right.
I'm entering the conviction. Yeah, you're not doing too well. You got in with the wrong crowd, huh?
Yes, sir.
Yeah, you got in with the guys that you just don't want to be within 48 miles of, you know? And not even 48 miles unless you don't have a car and you only have a bicycle. I get the feeling sometimes, Mr. Sluter, it bothers me to see people ruin their lives more than it does them. You know that?
Yes, sir.
You can go to rehab all the days you want, but you keep hanging around with the same thugs. And then that's what happens. You follow me?
Yes, sir.
All right, I'm going to sentence him anew. Give me a first page of a register, please. I'm going to sentence him anew. I'm revoking his status, entering the conviction, and we'll go from there.
Thank you.
Anything else?
I think we covered that. I just wanted to let you know that he is working full-time at the College for Creative Studies in Detroit. He's doing maintenance there. He's stable. He's living with his grandmother, who's in the line on a place to have his own place in Detroit. And again, he's been incarcerated since Friday.
Can I ask a question, Mr. Sluter? How many days were you, now, I don't want you to embellish. I do not want you to embellish. You said that was January 28th, right? And that was from,
Sacred Heart.
and they said he'd been in there how long?
At that point, they just stated that he was inpatient there and that he had gone inpatient on the 28th, and the letter was just stating that he's there. The maximum time that he would stay there would be about 30 days, but his average length would be 10 to 21 days. But it was just when he was admitted. They never sent anything to tell me after how many days he completed.
Right. How long were you at Sacred Heart? And I can easily find out, so don't lie to me.
I was there for 21 days and then I
what
left
happened?
there.
So you got out, hang on. So you got out sometime around February 18th. Then where'd you go?
And then I went to Lake Ridge Village.
How long
in
were you there?
Detroit. I was there up until recently, maybe about a couple weeks ago.
Hang on a second. Hang on. From February 18th until sometime in the third week of April, is that where you're telling me, what you're telling me?
Yes.
You were in? Then you didn't show up on your circuit court case, right?
Yes, sir, because I was in Lake Ridge Village at the time. And it
And
was
you've been
hard
out
to
how
get
long?
a couple weeks now.
And you didn't go over to the circuit court and surrender?
I'm sorry.
I'm sorry?
I do apologize, sir.
You don't need to apologize to me. I'm not the one serving the jail time. That's your gig.
Judge, I will say too, when he was sentenced, we did have proof he was sentenced June 18th of 2025. At that time, we had proof that he was in Sacred Heart and then also in a sober living facility since April 1st of that year. So he'd done about a little over 2 months, either in Sacred Heart or in a sober living facility at the time that he was sentenced.
Whoever's got the phone, it's got to leave the building, please. You got to take the phone out of the building, please. Thank you. 100 fines, 250 costs, 75 victims' rights. So I'm actually we're gonna do away with the $620 plus any late fees on the fines. I'm only gonna charge you 100, 250, 75, 50. So that's victims' rights and $50 justice assessment. So your total's 475. and 17 days. Credit 5, serve 12 more. You're going to serve an additional 673 days if you don't pay your fines. I'm going to let you pay those at the rate of $50 per week. I'm going to start that beginning on June the 22nd. Now, if you don't have the money, no problem. Call the court. We'll go on Zoom, or you can come in here and talk to me, and I'll be glad to give you an extension, okay? But if you ignore me, you're going to serve the other 73 days. Do you understand?
What about today? Like, how am I gonna get out of here?
You're in custody now. I gave you 17 days and I'm crediting 5. You're serving 12 more.
Okay.
Good luck. Thanks, Mr. Granata. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, sir.
All right, good luck. Concord versus Kelly Tackett, 2601496.
Good morning, Your Honor. Ralph Mayers, P23815, appearing on behalf of the plaintiff Concord Co-op.
Good morning, Mr. Mayers. You're looking good. What happened with this one? I don't have Kelly Tackett here. Is there going to be a dismissal or is it a default?
Well, Your Honor, there's still rent due and owing, so we would seek a default judgment for non-payment.
You can go ahead and proceed.
Amount of rent to retain is $1,196. And we have court costs of $179.58. Total default judgment proposed would be $1,375.58.
And your late fees are less than $75 a month, right?
Oh, they're down to 50, Your Honor.
Right, I knew that. So writ date will be in this case May the 14th, if you can get me that here this morning. Okay, Mr. Mayers?
We'll send that out today, Judge.
And you have one more. You got Concord versus Jamie Asunto, 2601497.
Again, Ralph Mayers, behalf of the plaintiff. Your Honor, the defendant has failed to appear. There's a good reason. While this was pending, I was informed by the co-op that the defendant passed.
Oh, no.
Nobody has come forward with letters of authority to represent the estate. However, once the co-op retains the unit back, and this is for non-payment, they'll clean it out, and then any refund of any equity would have to go to the estate. So we would ask for a default judgment versus Jamie Asunto, the estate of Jamie Asunto, and all occupants, Your Honor, and I have the amount due and owing.
Okay, go ahead.
The amount would be due and owing of $598 in carrying charges. That's through April. Court costs $179.58. Total proposed default judgment, therefore, would be $777.58.
All right. Writ date will be on the 14th of May. Default judgment's entered. That's a shame. So I'll ask you to submit your judgment. Good to see you, Mr. Mayers.
Back at you, Judge. Thank you. Have a good day.
You too. You know, the Supreme Court is asking us to remind everybody to fill out one of those public satisfactions. If you get a minute, I'd appreciate it. If not, I understand.
I would love to have that form to fill out. I don't have it.
It's on the screen here. Jennifer.
Oh, I see.
There's the
Thank you.
website is on the screen, Mr. Mayers.
I'll see if I can figure it out.
Okay.
Thanks. Have a good day. Samson Billy Alohi versus Sukrai Singh. Come on up here, gentlemen, 2601776. And also Michigan Truck Driving School, Inc. Samson Alohi?
Yes, sir.
Okay, good morning. Your name?
No, sir. Samson.
Okay. You understand good English, sir?
Yes, sir.
Okay. And who is Sukrai Singh? Your name?
Sukrasi.
And what is your name?
Sukal. I'm his partner.
Well, he's just, who owns Michigan Truck Driving School?
3 partners, so one is not cooperating. So
I'm sorry?
we were 3 partners, so 2 are here. So he's
All right, let me see this. Let me just figure this out, okay? So you're suing both of those entities, right?
Yes, sir.
So you're getting sued individually, Mr. Singh. You know that.
I just know now, I don't know this, you
You got to keep your voice up for me.
we are running the Michigan Rocket Driving School. The school has been shut down like a couple of months now. We are not operating any more business and we are 3 partners.
This isn't something I saw on TV, is it?
No,
Well, okay. You know you're being sued individually, right?
I just know now.
Okay. And then you have to tell me your name again, Mr.
Oh, SUKHPA.
Hang on, slow down. Say that again.
UKH
H
SUKHPAL.
SUKHPAL. And that's your
First name.
first name. Is your last name Singh too?
Yes.
And are you two related?
Yes.
What is your relations?
Brother-in-law. Brother-in-law.
How can he be? Okay, I know. Brother-in-law? So you guys have the same last name, even though you're brother-in-laws?
Just him.
Okay. All right. So I need to advise everybody here, you have the right to have the case removed to the General Civil Division. Anybody can do that. If you proceed in the Small Claims Division, you are giving up certain rights. Each one of you are giving up the right to hire a lawyer. Each one of you are giving up the right to demand a trial by jury. Each one of you are giving up the right to appeal my decision, no matter how good or bad you think it is. And to the extent that you are entitled to it, plaintiff, you're giving up the right to seek an excess of $7,000. If you're going to stay in the Small Claims Division, you would have to waive those rights. If you want to have the case removed to the General Civil Division, I'll still be the judge presiding in the case, but you can hire a lawyer, you can demand a trial by jury, you can seek an excess of $7,000, and you could appeal my decision. Okay, so you could have a jury trial, you could hire a lawyer, you could appeal my decision, and if you're gonna, that's if you remove the case. Do you understand that,
Yes.
Mr. Singh?
Yes.
And do you understand that, Mr. Sukhbal Singh?
Yes, sir.
And do you understand that, Mr. Alohi?
Yes, sir.
Do you wish to give up those rights and proceed here?
Give up.
Okay, if you waive those rights, we're gonna have the hearing now. If you tell me, Judge, I don't want to waive those rights, I want to have a trial by jury, or I want a lawyer, or I want to be able to appeal your decision, then just tell me and I'll remove the case to the General Civil Division, in which case you can hire a lawyer, have a jury trial, and appeal my decision. Do you understand that?
Yes, sir.
What do you want to do?
I want to wait.
I can't hear you.
I want to wait.
You want to,
I don't want to remove it.
okay, so you want to waive the rights?
No, I don't want.
Okay, slow down. Slow down. Do you want to waive those rights, or do you want to go to the General Civil Division?
No, I don't want to go to. I want to leave.
You want to waive those rights? Take your hand away from your mouth. If you waive those rights, I'm going to hear the case here. If you, right now, if
I want the case right.
you want to waive those rights, then
Yes, sir.
how about you, Mr. Singh? And I'm talking about you, Mr. Sukrai Singh. Do you want to waive those rights, or do you want to have the case removed?
We're gonna do here.
What's that?
You can do here.
You waive those rights?
Yes.
And on behalf of the company, do you also waive those rights, Mr. Sukrai Singh?
Yes.
Do you also waive those rights on behalf of the company, Mr. Sukhbal Singh?
Can I just know the clarification? What is the waiving? Like, he's blaming on $4,000 one.
Okay, you guys, I want to make sure everybody understands.
Yes.
Okay? I want to answer your question, but you keep your voice up nice and loud for me and slow down. So what is your question? Nice and loud and slow.
All right. My question is, we can move to our attorney, so we can hire attorney when we want to proceed.
Okay, you got to keep your voice up. Hi, I'm getting old
Yes.
and I can't hear everything.
Okay,
And
so-
now you guys got a little bit of broken English, which is fine. but it makes it harder for me to understand. Voice nice and loud and slow. Do you want to have the case removed to the General Civil Division and hire a lawyer?
Yes.
All right, they have that right. But you have to hire a lawyer on behalf of the company. Do you understand that?
Yeah.
So they have the right to have the case removed. And you understand what I'm saying, right?
Yes.
All right, so you have to hire a lawyer, though. You have to.
Yeah.
You don't have to, but you might want to, okay? I'll just make a note. Defendants want case removed. You also want it removed versus you? Either way, you don't have a case, you don't have a choice. Is that what you want, Mr. Sukrai Singh?
Yes.
I'll make a note. Defendants want case to be removed. You're gonna fill out a demand for removal, okay? Demand for removal. And then you're going to have to answer the complaint. So you better go get your lawyer today. I think it's 14 days, right, Jennifer? I think 14 days they have to answer the complaint. So you're gonna have to go hire a lawyer today so you don't miss that deadline. Fill out a demand for removal right down the hall right now.
Okay.
And then they have that right. So I'm gonna reschedule it and we'll set it for a pretrial. Do you understand that?
Yes, sir.
Do you understand that?
Yeah.
Do you understand that?
Yeah. Yeah.
All right, good enough. Have a good day. We'll see you back here. Thank you, gentlemen. Have a good day. Marquise Moses Vega. Where's Marquise Vega? 24W836-756A. Where's Marquise Vega? Is he here? Andrew Mara versus FHL Homes. Are they here? Come on up. 2601086.
Here to the podium. Here to the podium.
What's your name, sir, Mr. Mara?
Andrew Morrow.
And sir, what is your name?
Bob and Leo, L-E-A-L.
I'm sorry, can you spell the last name again?
Lager, Ella, Appelberg.
Okay, slow down.
L.
Wait a minute. Did you say your first name was Fabio? F-A-V-I-O?
E as in boy.
Fabio, I'm sorry. And then the last name?
L. E.
Okay,
A.
A-L.
L.
Leo. Okay, what is your position with FHL Homes?
I have a DBA.
Okay, so, but you have knowledge of the facts and circumstances of this case, right?
Yes.
Did you guys have a contract?
Yes, sir.
Yes, sir.
Do you have it with you?
Photocopy of it.
Good enough. Before we go on, I'll tell you too, you have the right to have the case removed. You do not have to proceed in the small claims division if you don't want. If you proceed here, you're giving up certain rights. You're giving up the right to hire a lawyer. You're giving up the right to appeal my decision if you don't like it. And you're giving up the right to demand a trial by jury. Do you understand that?
Yes, sir.
I understand.
Do you understand that, Mr. Leal?
Yes, sir.
And you understand that, Mr. Mara?
Yes, Your Honor.
And to the extent that you might be entitled to it, you're giving up the right to seek in excess of $7,000. Do you understand that, Mr. Mara?
Understand.
Do you wish to give up those rights and proceed here, or do you wish to have the case removed, Mr. Mara?
Just to waive those rights and proceed with small claims.
Do you wish to give up those rights and proceed here, Mr. Leal, or do you wish to have the case removed to the General Civil Division?
We'd like to continue here.
You waive those rights?
Yes, sir.
Raise, do you have any witnesses, either one of you?
Okay.
Raise your right hands. Solemnly swear affirmative penalties of perjury that the testimony you give in these proceedings will be the whole true self you got. Mr. Murrah?
I do.
Mr. Leal? You have a contract?
Yes, Your Honor.
What did you hire FHL Homes to do?
Hired them to do cement work on my private residence,
Where at?
18335 Emmett Road in Brownstown, Michigan.
Yeah, I understand, but what, the driveway or what?
Driveway is slab.
Driveway and slab, okay. And did they do that?
Yes, Your Honor.
And what happened?
So the plan was on the slab portion that a structure was going to be placed on top. So when I went forward
Where was the slab going to be?
at the end of the driveway. It's
Do
supposed
you have a
to be-
picture of it?
Yes, Your Honor.
Let me
Not of the actual cement work, but of the structure. And so I have the,
Well, then hand it up if you would, please.
We're gonna give you some documents too.
Okay. Let me see your contract too. Oh, jeez. I haven't had it on the whole time.
no, it was not, it's been a while.
All right. Okay, I hope you have another copy of this for yourself.
It's gotta go. Where the phone was trying, it's gotta go to the building.
Do you?
I do not, I apologize. I gave a copy to the court when I submitted the paperwork.
Let me see something. Maybe it's in the back here. Yeah. It's a little different type, but good. I can hand you this one back. John, 16. All right, so you tell me what happened, Mr. Mars. So you hired them to do cement work and put a slab at the end of the driveway.
Yes, sir.
Where's Emmett again?
It's in Brownstown.
I know, what street? I mean, by what streets?
It's north of Sibley, east of Telegraph. Right by the elementary school.
Okay, so what happened?
So I made it very clear what the end game was for the slab portion that the structure was going to be placed on top. I'm not a contractor, so I had them go ahead with the permit with Brownstown Building Department. So through the time, it was very clear that
What did you want a slab at the end for?
that is going to be the foundation of the structure that's going to be placed on top.
What kind of structure?
It's gonna be a metal garage shed. I have the dynamics in paperwork as well. So
So this is at the end of a cement driveway?
yes, this
How close was this going to be to the street?
had the length of the driveway itself, which is 9 feet, about 6 feet,
67 feet.
67 feet, I apologize.
Can I answer the question? I'm trying to visualize this. Is there a picture in here somewhere?
Not in my paperwork.
That's a picture of my insurance.
I see.
There's a picture.
So there's no public sidewalk there on Emmett,
No.
right? And where did you want it in? Was it going to be, see this car? Can you see that car in the picture here or not? I know, but that car, can you see the car?
Yes, Your Honor.
Was the slab going to be behind the car?
No, it's gonna be in front of the car, next to the residence. It's supposed to be like a garage structure next to my home.
I see.
To the driveways lead to the structure, the slab from the roadway.
So what happened?
So I contacted the steel company who's gonna come and put the structure on top, and I said you can go ahead with the permit to erect the structure on it.
You said that to who?
It's American Edge Steel. That's who the company that's gonna put the structure on.
Okay.
Gave them a go ahead that everything is done, the cement was. They contacted me a few months later, stating that Brownstown reached out to them and they denied the permit. So I asked the reason why the permit was denied. They said there wasn't a proper footing around and the perimeter of the slab. So a structure cannot be put up top. So, and then I contacted Ruben and
Not a proper footing around the
the slab.
the slab?
Yes.
Okay, so they denied the permit.
Yes.
Did you know he was gonna put in this structure?
He present, like you said, a metal shed. Doesn't require no,
Wait,
he asked for a metal shed that is right there on the exterior. The instructions of the company does not include any footing. It only says concrete slab. There is a exhibit there with the proposed, that is the exhibit, right?
Okay, sir, I want to make sure I'm understanding everything that you say, okay? When he contracted with your company, did you know he was going to put a structure out there?
He give a drawing,
Say that, hold on, wait. I'm having a hard time understanding you. So, go ahead, but nice and loud and slow,
Exhibit 5
okay?
shows a metal shed supplied by Mr. Morrow.
He gave that to you when he was contracted, right?
Yeah, that is a metal shed. The drawing supplied by him doesn't indicate anything at all. It says concrete slab. The drawing that was presented to him and approved shows concrete slab. The permit submitted to the city and approved by the city is concrete slab.
Did you guys did you acquire a permit that allowed him to put up a shed?
I submit to me the drawings. And that's what he approved. And that's what he was done.
Okay. I want to slow down. I want to ask the question again. Did you acquire a permit that allowed him to put up this shed? Yes or no?
The permit was pulled for the concrete slab that doesn't require no footing. There is a.
Say that, repeat that.
The concrete, the permit that was pulled was according to the drawing, and the drawing showed there is no footage there. And was submitted to the city kept still
You
instruction.
know what I'd like to do? I don't mean to interrupt you. I want to get whoever it is at the township that denied the permit. And I'd like you to bring in whoever it was that you were contracting with to put in the structure. Do you understand what I'm saying?
Yes, sir.
So I'm going to want, what building inspector were you dealing with?
There is no permit there. Concrete.
And emails in regards to have Andy go there.
Andy who?
Go there.
Okay. I want you to contact him, and you probably should subpoena him. And I want you also, one of you guys, to subpoena American, whatever it was. Whoever was going to put the structure in, you gave me their name. I'm sorry?
It's in the exhibit.
Subpoena them too. I feel like I need to know more about this. Okay?
Your Honor, I'm not too familiar with civil proceedings. So when it comes to subpoenaing the people that you want, I can do that on my own accord. Just tell them to come in.
Well, that is not a court order. Jennifer, you're going to explain this to them. They're going to prepare an order to appear. And you're going to have to tell us the name and address of the people. And if you have their phone number, that's perfect. Then you can hire the process server to go out and serve this, okay? Then we'll make sure that we have everybody. So we're going to adjourn this. I'm going to give you enough time. Adjourn. So township official, and I'm talking about the building official involved, and individual who was to put in structure. How bad would it be to put in footings now? I'm just asking a stupid question. How hard would that be?
That's a good question. I tried to contact him because he didn't directly with Ron Torres. It was a friend that make a favor to pull it for me. And he dealt with Mr. Ruben Torres all day long. Once he sent me the notice that it was a problem, if you look at the exhibit number.
Okay, I'm just asking that question.
That's what the question is about. I said, They said very clear, this is Mr. Favelio. What's the problem with Mr. Ruben Torres? Did he finish the work?
Sure.
Please call me.
Okay, let's do this. You subpoena the person who was to put in the structure or the principal, whoever you were dealing with from that contract, from that outfit, and you subpoena the building official. Sir, what language do you speak?
Spanish. Now, I tried.
Hang on. I'm not going to go on this, but I think I need a Spanish interpreter. I really do, because you know, you do fine, but you speak with broken English. And I want to make sure that I have every word just to understand. Okay. So I'm not trying to insult you in any way. I'm going to get a Spanish interpreter here. Okay. Just to help me to make sure that I'm not missing any words. Okay. Is that fair?
Right.
So that's what we're going to do, Jennifer.
Could I listen to you?
Not yet. We're just going to adjourn this. I'm not going to change my mind at this point. Jennifer, I want you to take all these. He brought me some pictures. I want all their stuff copied off and the originals given back to them. Okay. I'm going to have John bring this down, but give me a date in about a month.
June 15th.
We're going to adjourn it to June 15th. That'll give you plenty of time. Mr. Mara is going to get the subpoenas. You're going to
Yes,
give
sir.
him the subpoenas and you're going to fill them out, but then I'm going to sign them. Okay.
Your
Or
Honor,
the
we can,
clerk.
if it's subpoenas for appearances, we can sign them
I
as
know.
clerks. You
I
don't
know
have, yeah.
that. I
Okay.
know that, but it maybe they'll take it a little more serious if the judge is signing. I'm not worried about the Brownstown official.
You want
I'm
to
worried about
got
the
it.
other person putting in the structure. So I'm going to go ahead and do that. All right.
If the company is out of state in Ohio, is via Zoom acceptable?
Oh my God, they're out of Ohio.
I believe they're based out of Ohio. I'm not sure what the representative that I spoke to is located or who tried to get in permits.
Did you deal with somebody in state?
No, it was all via phone. I'm not sure what they were based out of.
Technically, I can't really issue subpoenas. Well, let me think about it. Did you enjoy a decent relationship with them? Maybe they'll just show up voluntarily. The Brownstown official, I would subpoena.
Absolutely.
The other ones, see if you can't get them to come up, and I'll be glad to let them appear by Zoom.
That's acceptable.
I'll let them appear by Zoom. And Jennifer, I need you to flip through all of this and make sure that we get back everything to the other side, okay? What? Yes, sir. And I need a Spanish interpreter. Yes, sir.
I would like to answer the question that you asked. Can the footage be fixed?
Yeah, tell me.
So we're gonna investigate and we go to the city public inspectors.
That's why I want to get everybody here.
If he has any solution.
That's what I want you to do. There's nothing wrong with you talking to him now and saying, what solutions can we come up with? You
That's
two,
answer the phone.
Mr. Mara, maybe you guys can work this out. Call the city, the township, tell them what I'm saying, see if you can't figure something out.
Ruben did come up with a solution, but gave me an estimate of $7,100 to correct it.
Jeez. And how much did you pay him? You paid him 10?
I paid him $10,000 flat.
Oh my gosh. Let's get everybody here. If you guys can figure something out, God bless you. I'm good with it.
Absolutely.
Talk to them, okay? And I'll see you back here June 15th. Go down the hall first, get your notices. You
So
can
if we
get,
don't get an agreement, we'll be here on the June 15th.
right. And either way, you have to let us know if you do settle it with a dismissal order, okay? Jennifer, call Ms. Villarreal and tell her that I would like her to do this if she can, if you're capable, if you're able to call her direct. I don't know how those
Yes,
companies are
I will
working.
reach out to her. If not, I
Thank
have
you.
her email.
Thank you. We're all set. Go down the hall. Vega, Marquis Vega. Did he come here and show up and leave? Do you know, Jennifer, I got a criminal case here for time
I'm
to pay.
asking right now, Judge.
I'm sending this file back down. Anthony Hall versus Top Speed Performance and Repair. And then I've got a counter complaint. Top Speed Performance and Repair versus Anthony Hall. Wow. I can tell none of these are gonna be easy today. Hang on one second. Is Jill Malinowski here?
Yes, sir.
I'm gonna take that one first. That looks like that might be a little easier, but I'm not sure. Have a seat, guys. You can have a seat right at the table. Jill Malinowski versus Camarina Orozco Israel Alejandro. 2601696. Have you guys talked here, by the way? Anthony Hall and Top Speed Performance and tried to resolve this?
Your Honor, we
I
have,
just asked if you tried to resolve it.
yeah,
Any sense in you guys talking again?
I don't think so.
Okay, come on up here, folks. Your name, Ms. Malinowski, again?
Jill.
And your name, sir?
Israel Cameron,
All right, you're the defendant. Who's this with you?
my wife.
What is your name, ma'am?
Sabrina.
All right, you're not, how do you spell your last name?
CAMARENA.
Okay. I'm not sure really what this is, but I'm going to tell you all, you have the right, or at least you, Mr. Camarino, and you, ma'am, Ms. Malinowski, that you have the right to have the case removed to the General Civil Division. If you do that, you will be able to preserve certain rights. If you proceed in small claims, you're giving up the right to appeal my decision, to hire a lawyer, to demand a trial by jury, and to the extent that you might be entitled to it, ma'am, in excess of $7,000 you could sue for. If you waive those rights, you're staying here, but you can't appeal my decision, even if it's the worst you've ever heard of. You can't have a jury trial. You can't hire a lawyer. Do you understand that? Do you understand that?
Yes, I do.
Do you wish to give up those rights and proceed here or have the case removed,
I
ma'am?
wish to hear your answer.
Sir,
I'll proceed here.
you waive those rights?
Yes.
Raise your right hands, everybody. Are you a witness?
Yes.
Raise your right hands, everybody. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got, ma'am?
Yes.
Sir,
Yes, I do.
ma'am?
Yes.
All right. So I'm reading this police report narrative.
He's walking. He was in the jury room.
I'm asking you to, he wanted 2,500 up front and 25 at the end of the job for parts and labor, right? To do your kitchen?
Yes, that's what he asked for.
Did you guys have a contract?
We had a verbal contract. It was 5,000.
Why do you guys do that? Why would you do verbal? I wouldn't verbalize a contract over this pen. You can't.
There's documentation in here, Your Honor.
Let me see what you got. What didn't he do? You can hand that right to her. What didn't he do?
He started.
How much did you pay him, by the way?
Paid him $2,500 to start the job.
Okay, is that true?
70, yes and no.
I have his.
Wait a minute. Woo,
I have.
woo. What do you mean technically, yes?
So-
Did she give you 2,500 bucks? or did
She
she?
did give me a deposit.
Was it 2,500?
Yes,
All right, then what do you mean technically?
but it wasn't.
Listen, I just want you guys to answer my questions.
No, I will.
I don't want to be rude about this, but technically, yes or no is about the worst answer you could have given me. Either she gave you 2,500 bucks or she did. All I asked was, did she give you
She
2,500?
did,
Okay, so we all agree on that.
yes,
And that was supposed to be the initial deposit, right?
yes.
Okay, so then tell me what happened.
During that course of time, he came and installed a refrigerator.
Installed, when did you give him the 2,500 bucks? What day?
Was given to him to start the kitchen on 12/6/25.
Okay,
During the course of that time, $400 was given to him on 12/21 for extra work that needed to be done in the kitchen. And
wait a minute. Now, did you guys amend the contract? Or was that just toward the 5,000?
that was a little extra because he ran into some problems and needed the extra 400
Well, okay.
to correct those issues that he ran into.
You know, you guys would save yourselves a lot of time if you got lawyers and money to deal with these. So you gave him $400. Do you have it documented what that was for?
Yes, I do. It is in there. It is for the extra work that needed.
What kind of extra work?
The plumbing underneath the sink.
Okay.
Needed to-
Is that true?
Just negative.
Okay, how much did she give you?
So the 400 that she's talking about was not for that. The plumbing was done almost at the end of the.
What was the 400
job
for?
there. The 400 that were there was for additional parts to install the fridge. So the $2,500 went towards installing the fridge in the wall, which initially was not supposed to be in the wall. It was supposed to be out the wall.
I see.
And I gave her an idea of putting the fridge where she had a closet, open up the wall and insert the fridge in there. So that was
You have documentation to tell me that the 400 extra was for the plumbing underneath the sink.
He came across, yes.
Where's your documentation?
It's in the packet, sir.
You gotta
I
be
have
a little, wait,
signatures.
slow down. You gotta be a little bit more specific on that.
And there's the pictures that were taken of what the kitchen.
Now, you guys wrote, gave Israel $400 for the extra work that needed done for kitchen. That's what it wrote. You both signed it. Now,
Yeah.
how am I supposed to guess at that? I don't know what that means. Does that mean for the plumbing? Does it mean for extra parts because you wanted the refrigerator inserted into the wall as opposed to outside?
The original plan was for to have the refrigerator put into the
All
wall.
right, so where do you have that at?
That was in the cost for the whole remodel.
All right, you have that documented.
Yes, it is, the floor plan is in there.
Okay, slow down.
Pictures.
Slow down. Let me just look. I'm telling you, well, I don't see anything that says,
Your Honor, can I show you this? So you can see the date and the time?
I mean, I want to know from her first.
Okay.
Where's it documented here? What date?
It's on the pictures. He started the job on 12
Did you
days.
give me the pictures?
Yes, they are in that folder.
Are they in the folder here, Jennifer? Oh, the whole folder?
Yeah.
Okay,
I'm sorry.
that's okay. All right. What am I supposed to do here, man? I mean, I don't mean to sound
I just.
rude, but I can't. But you've got 25, 30 pictures here. And you're gonna have to find documentation in here right now that tells me the $400. Here you go, Sadie. I don't wanna have to, I don't wanna have to go through everything here. You're gonna have to present your case. Tell me where in there that you have documentation that tells me your extra $400 payment was for the plumbing as opposed to where the kitchen is, where the fridge is going to be inserted. Just wait 1 second, give her a minute.
No problem. Be patient.
You know what I think I'm gonna do, Jennifer? I'm gonna do a video that tells people how to deal with small claims. And then I don't have to,
From the plumbing that was done underneath the sink.
now, wait a minute. Okay. Did you do new plumbing work under the sink?
Yes, I did.
So now how does this picture tell me that the $400 was for that as opposed to where he's putting the refrigerator?
The original plan, when we came and discussed this job,
You've got to show me the documents.
it is written out.
Show me.
It was in that original packet, sir.
I want you to show me. Look, here's the deal, everybody.
So all monies that were transferred and work was not done.
Ma'am, you already told me this. You said gave Israel $400 for the extra work that needed done for kitchen, December 21, 25. This does not tell me, doesn't come close to telling me whether that was for where the refrigerator was going to go.
The refrigerator was included in the $2,500 at the start of the job.
Show me where. You're not showing me still. You're still not showing me. You got to show me. This is the problem when people try to do things on their own. Look,
Your Honor,
just wait one second, please. Mr. Harris, Mr. Donofrio, listen, guys. I read your motions. Where's Mr. Harris? Can he, when he comes back out, I'll get him.
I'm here, Judge.
Look, can you pop in here? Listen, here's the deal. I read your motions. I got 2 small claims cases that look like they're going to take a long time. I'm going to mass at 12 o'clock. My father died 40 years ago today, and I'm not going to be late, and it's about a 15-minute drive. Can I get you two to pick a time tomorrow when you can come in here?
Absolutely, Judge. Oh, sure, Judge.
Let's do that. Would you chat with them, Jennifer, and pick a time for tomorrow, please? I don't care. I know I got state. It's all right. We can do it at 8:30 whenever they're available. I'm sorry about this. I really am. These small claims are going to take, they just take time, and I'm really sorry.
No problem, Your Honor. Not at all.
Okay, so Jennifer, pick a time with them that's convenient for both. If they can't do it tomorrow, we'll do it Wednesday. Okay, thanks.
Okay, Your Honor. I'm going to just take them into a breakout room.
Thank you very much. All right. Now, ma'am, I want you to listen. I don't want to get bogged down in this one. Do you have documentation that $5,000 included putting the refrigerator back into a inserted area? When you say inserted, that's what you told me, right?
Yes, it was a closet behind the
Right.
wall, because the first initially was gonna stick out. So
Do you have documentation that tells me that that $400 was for the plumbing instead of that, ma'am?
No, the total cost was for 5, and
I know, but does the $5,000 total cost include putting the refrigerator?
Yes,
Where,
Yes.
show me where that documentation is.
it's gave Israel deposit.
Ma'am. You gotta,
It was agreed upon us that $5,000 was to.
if you don't have it in writing, that's fine. Just tell me that. If you do have it in writing, show me where. That for the $5,000, he's gonna do X, Y, Z,
Yes.
but show me where.
Listed on here for
Show me where. Read it to me.
door molding.
Read it to me. Read that part to me.
Kitchen.
Read that part to me where he says he's gonna do that. You're gonna, that's included in the initial $5,000.
I don't have documentation of that.
That's all I've been asking you.
Okay.
And you told me yes 4 times, and now you're telling me no. You don't. So I just need you guys to answer my questions. Small claims are difficult. They're very difficult for judges because people want to talk about what. All right. So you guys have a dispute as to whether or not the $400 was paid for the resetting of the fridge or the plumbing underneath. Okay, what else happened? Underneath the sink, I should say.
From the start of the job, the $2,500 was given to start the job. On numerous occasions, we had agreed that he could only work weekends, which I agreed to, that was fine. On the weekends that he was supposed to show up.
You guys, hang on. Mr. Hall, do you live in Detroit on Aurora? You had to drive here, right? If I get all your documentation, so you don't have to come back, and you can do it, you know how to operate Zoom? Let's see. I just don't think I'm gonna get through all these. I can tell. They probably think it's simple too. Why don't you guys go out and talk again, okay? You guys, I'm just telling you, I don't think I can get through it, and I hate to have you wait for another 45 minutes only for me to not get through it. Why don't you guys go talk? Do you have a contract that sets forth all of this?
Yes.
You guys see what you can resolve. If not, I'll be happy to adjourn it. I hate to do that to you. I'm sorry. Small claims can take nothing and they can take all day. Go ahead, Ms. Malinowski. So what else?
So at the beginning of the job, when the $2,500 was given, the refrigerator was placed into the wall that was in the original plan.
You didn't say that. It's not in writing, but you're telling me that's the verbal
This is
agreement.
what we agreed upon.
Okay, and then what?
He came in, he did do the fridge. After the fridge was installed, I had to wait on cabinets to come in from Lowe's. There was a problem with the cabinet, so it was put on hold for a minute.
Okay, what do you mean a minute? What do you mean a minute?
I had to wait for 6 weeks for them to redo a cabinet because it came in damaged.
Okay,
So in the course of
but it
that,
wasn't his fault yet, right?
that was not his fault.
Okay.
You're right.
So go ahead. So now we're into February before the cabinet work's gonna be done, right?
Yes,
Okay, go ahead.
so January. He asked for $900 on the 13th of January. For the supplies to buy the door moldings, the stain, burn the wood. For the kitchen, ceilings, door moldings coming in and out of the kitchen. And labor.
Okay, is that true?
Yes,
And that $900 for what? Was for what?
was to purchase the wood,
Base wood you're talking about?
the molding.
Right.
Yeah, to purchase the molding, just regular, 1x4s, burn them up, stain them, and install
Okay,
Which I have not seen the price for.
where's that at?
them. So her house is 15 minutes away from Home Depot and Lowe's.
Wait a minute. He never did that work?
No,
You never did that work?
I didn't install it
Why?
because the problems that we were running into, doing this, doing that, change this,
Wait a minute.
everything was getting changed. The original plan of this was just cabinets. Cabinets and.
When is the last time you did work at that property address?
Yes.
When?
When was the last time?
Has he been back there after he did the initial work? And
No, I couldn't.
He was.
Well, then you clearly owe her money, right?
He was.
All of her money?
No, he's been back, because it was raining that day, he went back, yes, he did go
No.
back.
Wait, I was asking him the question.
Yes, no, I went back on a Saturday.
When? What month?
I'll give it to you right now.
Am I right that so far you were paid $3,800?
Yes,
And what percentage of the work have you done?
that's what I'm trying to explain to you so you could get a perfect understanding. She should have the first picture of the diagram, how the job was gonna be done, which was nothing with a fridge inserting it, no molding, no drywall work. Just me go into the house, install cabinets, install the sink, move the electrical for the stove from one end to the other end of the where the cabinets were gonna be at. That was the only thing.
Let me ask you a question.
There was no top cabinets.
Let me ask you a question. When you asked for the $900 addition, up until that point, well, let me ask you this. When you got the initial $900, have you performed any other work at her residence?
Yes,
What have you done?
I started doing the plumbing, started moving the plumbing where I needed it to be at, where the sink was gonna go. So everything was gonna get changed around.
How many hours did you work?
It was just weekends.
I didn't ask you that.
No,
No, no,
How
guys,
many hours?
guys, I want you to answer my question.
I couldn't tell you how many hours. I mean, it was
Well, you gotta kind of know this, don't you?
12 hour days,
Pardon?
just on the weekends,
I-
Saturday and
It
Sunday.
could be 6 a.m. until midnight. It could be from 10 to 2. I need to know how many hours that you worked there after she gave you the $900.
I couldn't tell you, Your Honor.
Well, then you don't have a very good case here. How many hours of work did he do, ma'am? After you gave him the $900 additional payment?
Maybe between 8 hours.
Is that fair?
No,
How many did you do? You can't tell me, so how can you dispute the 8 hours?
after those 900.
Listen to me.
The
I'm gonna ask the
policy-
question again. I'm gonna ask the question again. After she gave you the $900, how many hours did you work at her residence after you received the $900 that was supposed to be for the moldings, the staining, installation?
I just went and, say 8 hours.
Okay,
I'll say no.
so you agree.
Yeah, I'll agree with that.
What did you do in those 8 hours?
I went to go purchase after those $900, I went to go purchase the material.
What materials?
1x4s,
How much did those materials cost?
1x6, she had the receipts.
How much did the materials cost?
Do not have the receipts. The money was given to him on the 13th of January for the moldings, to stain and burn the wood, for the door moldings inside, outside the kitchen door, the ceiling in the kitchen, and there's a
So to stain and burn the wood and to buy the moldings, right?
yes,
And what else? Anything else that was she was supposed to do for that $900?
no, and plus labor. You
Plus-
included the labor.
Now,
Yes,
was that toward the 5,000? Was that supposed to be toward the 5,000 you paid, or was that going to be in addition to the
that
5,000?
was in addition to the $5,000 to do the total job.
So you were gonna pay him 5,900 at this point, right? And what did you do? Did you buy the moldings?
Yes, everything was placed.
Okay,
in-
stop there, young lady. I don't know who you're related to here. Her, right? Who's this? I know, but just,
She,
I know, I get it, but I don't need people, I don't need them shaking their head up and down or side to side.
I bought her as a witness.
That's fine. How many hours did you work there, including purchase of the materials? And of those 8 hours that I think we've all agreed to, or at least you two have agreed to, that you worked, how much of that included purchasing the materials?
Purchasing the material was like around 600.
Wait a minute, what does that mean? That's how much you actually paid for the materials?
Just for what I needed for the meantime, yes.
Guys, okay, so I'm asking you, of the $900 additional that she paid you on January the 3rd, was it?
January 13th.
13th, I'm sorry. You said you spent 8 hours, right?
Yes,
And that included going to purchase the materials, right?
that was just including to purchase the material, yes.
What do you mean just including?
That was not the installation wasn't.
Are you telling me you spent 8 hours, the whole 8 hours purchasing the
No,
materials?
no.
Okay, so listen to my question very carefully. I think I'm doing a pretty poor job here. How much time did you spend going and getting materials after she gave you the $900?
I would say like between 4 and 5 hours, between 4 and 6 hours.
How many, where'd you go? Home Depot?
Home Depot.
How many trips did you make?
One trip,
It took you 4 to 6 hours to buy the materials?
yes.
Am I missing something?
They gotta get the wood that I need from the top shelf, so I have to wait
4 to 6 hours?
and load it up, take it to her house, unload it.
Did you take it to her house?
Yes, I did.
No, he did not, Your Honor. I have no supplies for that 900 that she's given. I have no supplies from that money.
Did you ever do any of the work?
No, not for that term, not.
Well, you said you spent 8 hours and it took you 4 to 6 hours to buy materials.
Correct.
Of the latter part, the 2 to 4 hours, what did you do to earn that money?
Excuse me? I do have little.
Okay,
bad hearing.
Okay, so let me keep my voice up nice and loud. Of the 8 hours that you said you spent after she gave the $900 to you, right? That's what you told me. And that's what she said, right? You spent 4 to 6 hours acquiring the materials, right?
Correct.
That means you're either 2 to 4 hours short of 8 hours. You follow me?
Correct.
What did you do work-wise at her house during that period of time?
Like I said, I want to purchase the wood.
We already know that.
Okay, so I unloaded at her house. I couldn't do anything with the wood because it was raining. I need the wood outside so I could start burning it and so I could stain it.
Did you do any of that?
Did I do any of that?
Yeah.
No, because I couldn't do it. The weather was not cooperating.
Hang on,
And she knew it.
hang on,
Your Honor, Mayor.
hang on. Are you telling me that other than going and getting the materials, I don't want to put words in your mouth. Other than going and acquiring the materials and bringing them back to her residence, you didn't do any work at the property at all then, right?
No, I did do work at the property. I didn't work with molding.
Listen to what I'm asking. Are you listening to my questions?
Yes, you're asking me if I did any work.
You told me you spent 8 hours. Then I said, how many hours did you spend getting the materials? You said 4 to 6. Then I asked what other work you did, and you said you brought the materials over, but weather didn't permit, so you didn't do any work.
No, I did do work in the house. I didn't.
After the 900
Yes.
was paid, after the 900 was paid to you,
Yes.
I must be really doing a horrible job today. I'm ready to go, maybe I should quit and go sell hot dogs somewhere. I don't know what to say to you. You're giving me all kinds of answers. I don't know what to believe anymore. What kind of work did you do at her property after she gave you the additional $900? You said you went and got the materials, and you said that took you 4 to 6 hours, and you said that then you dropped off the materials, which, by the way, she denies. I'm just trying to figure out what else you did after she paid the $900 other than go get the materials and drop them off. So tell me, what did you do?
The wall panels. I was installing the wall panels.
Is that true?
No, that's not true, Your
How
Honor.
long did that take you to install wall panels?
I installed it and
Wait, how long did that take?
Go ahead.
No, I want you to answer.
No, so they installed one wall panel. I installed the rest of the wall panels because they couldn't do the job.
How long did that take?
It took me to install the wall panels. It took me around. I do the job by myself, so I would say like 4 hours installing wall panels.
Then you way underestimated what you told me before. Because before you told me it took you 4 to 6 hours to get the materials at Home Depot.
Correct.
And then you told me in addition to that, you spent time going over and dropping off the materials. How long did that take you?
And when we were talking about the 800, I thought we were just talking about based on the money for the material. But doing the wall panels, it took me 4 hours to put the wall panels up there.
Well, then you way underestimated the amount of hours that you spent working there after you gave the $900. When you told me it was 8 hours, you just said you took 4 hours to do the wall panels. It took you 4 to 6 hours to get the materials at Home Depot. And then in addition to that, you brought the materials over. How long did it take you to drop the materials off? But they were in your truck, right?
They were in my truck, correct.
And you were at your house.
At where? At my house?
Did you go straight from Home Depot to her house?
Yeah, to her house. It's 15 minutes away.
Okay, So how long did that take you in addition to the 4 to 6 hours that you were at Home Depot?
It took me 4 hours right there at Home Depot to unload my truck. It took me like an hour because I gotta go around the vehicles in the garbage.
You said 4 to 6 hours it took you to get the materials. Did that include or not include the time it took for you to drop off the materials at her house?
Yes,
It wasn't a yes or no question. Did it include or not include the time that you took to drop the materials from Home Depot off at her house?
it didn't do that.
Did not.
No.
So when you said 4 to 6 hours at Home Depot, you said 4 hours for the wall panels to be installed. That's at least 8, maybe 10. And now you've got extra time dropping off the materials, right?
Correct.
And you're saying he didn't install the wood wall panels.
No, Your Honor, he didn't. I have pictures of my son and my husband putting them up themselves.
Let me see. You know what I want to do? I'm going to come out there and look at this. I'm going to come out and look at it. You guys want me to come out and look at it?
Yes, Your Honor, I would love to.
Can I see those pictures too, Your Honor?
Sure. John.
May I say something, Your Honor?
Sure.
The last time that Israel was at our home was on February 21st.
What did he do then?
He was supposed to, put the countertops together. It was raining that day.
Is that when he brought the materials back?
No, I have no materials for moldings, any of the 900 that was given to him. He came, which is Saturday, the 21st, it was raining, to do countertops. He said that he could not do the countertops that day because it was pouring down rain. I said, well, can't you just do the countertops in our fireplace room that's connected to the kitchen? That's our work area right now. No, they need to be taken outside to be done. He said, I will be back tomorrow on Sunday if weather permits,
On February 22.
on February 22.
And he come back?
No,
Was the weather all right?
yes, it was beautiful.
Was it?
Yes, it was.
Why didn't you go back? Or did you go back?
She wanted the sink installed as well. I can't mess with the plumbing because I have to turn off the main. And I will not be back Monday because I have to work my job. And I told her that. I'm not gonna be back Saturday. I'm not gonna be back Sunday for that reason. Sunday night, her son calls me, threatens me not to go back to the house. Because if I do, I know that he carries a CPL and I know what would happen if I arrive to his house. I told him, just put my tools in the porch, I'll pick them up. They told me no, nothing was gonna be put on the porch. And when he told me that he has a CPL, and if I arrive to his house, I will know what happened, I called the cops. I did the police report I didn't do the police report with the cop. I did, call dispatch, I reported what was going on, and dispatch sent the police to their house. When the police arrived to their house, my tools were
On
on.
Long Meadow?
What was that?
On Long Meadow?
Yes,
Yes, sure.
Good.
when the police arrived to their house.
Why was your son telling me he had a CPL?
My son did not tell him that, sir.
Does your son have a CPL?
Yes, he does, but my son did not tell him that.
How do you know that?
I was with my son
Because-
today.
Wait on. If your son didn't tell him that, how did he know that your son had a CPL?
When he was working at the house in conversations. My son was in and out of the house. That was not.
Do you have any
My son
idea?
does have a CPL, but
Do you have any idea how he knew your son had a CPL if he didn't tell him?
I do not know. that.
Thank you.
Yeah.
Okay, fair enough.
He's not gonna tell you because I'm a felon and I tell all my customers that I'm a felon. And her son came in there intoxicated with his cousin.
All right. I don't
Hang
want,
on, Your Honor. They were talking crap. And his cousin was going too hard on her son. Her son pulled out his gun, tried to hand it to me and told me, shoot him. Shoot him if he wants to, Israel.
what is going on in this world?
That is not true.
Okay. I want to come and look at the property. Did you see the picture?
Did I take pictures?
No. Did you look at the picture that she
Yeah,
showed?
the one that her husband is standing next to it. Yeah, that's the job that I did.
You did that?
Yes, I did.
Where's your husband?
My husband is at home, sick right now with cancer.
I'm
He
sorry,
did not come today. But I do have,
your daughter. Who is that?
that is my soon-to-be daughter.
Which she was never there when I was doing work. She was always in the basement.
How much money did you pay him in total?
In total, $4,100, Your Honor.
And what work still has to be done? Do you agree with that?
4,100, yes.
How much work still has to be done?
March 13th, after we let Israel go, we called him and told him he was no longer allowed on the property. He left us 7 weeks with no running water, no means to cook, no stove. On the 13th, I had another contractor come in the home to get us functional. Right now, we do have a sink that the contractor put in for us and the stove.
But no cabinets.
The cabinets, yes, the contractor put those in for us and got it.
What contractor?
Wait,
Another one?
yes,
How much did you pay him?
I have paid him $2,800 to get us functional.
So you have $6,900 into this job. How much has not been done of the job that you want? What you guys in your mind agreed to contract for, how much has not been done? What has not been done?
I still have moldings that the contractor needs to put up.
How much is he going to charge you to do that?
He is charging me $800 to stain, cut them, and put them all up throughout the kitchen.
Where'd he-
Doorways included,
What's that?
and the doorways, molding doorways.
So now you're into 7,700, right?
Correct, Your Honor.
And what else needs to be done?
The floor needs to be done, but that was not part of our agreement.
Okay. And you paid him 41. So essentially you are out, if you will. Would that take care of what you told me the contractor is going to do? Would that take care of everything
Yeah, sure.
that you contracted with Mr. Camarino, Camarina to do?
Yes,
But you only paid him 41, but you contracted to pay him 5,000, right?
correct.
Plus you added some things.
Correct, Your Honor.
What things did she add?
The molding was added, the bridge was added.
I'm still trying to figure out if you dropped off the molding. Somebody's lying to me here. Wait a minute. Somebody is lying. And I'm going to find out who it is. And they're not going to like what I'm going to do. I'm going to ask you to one time. Did he drop off the moldings?
No, Your Honor, he did not.
Did you drop off the
Yes, I did,
moldings?
Your Honor.
Where did you get the moldings you just referred to as the new contractor having to put in?
I have not purchased them yet. I have to repurchase all the molding.
Do you have a receipt for the moldings that you
I
purchased?
gave them all to her.
You have them?
I do not have receipts, Your Honor. I do not have.
You got the copy though.
No, I give her all the receipts, then she writes it on the paper. This is paid, the molding was paid.
Where's where's your copy of it if she gave it to you?
No, she has the papers. I don't get a copy of it.
I had him sign, Your Honor, every time money was exchanged and what it was for. But I do not have the supplies for the 900 that he asked for to do the
Is
mold.
that true? Did she have you sign all these documents?
Yeah,
But you
and
didn't,
when I signed it was because she's satisfied and her stuff is there. It doesn't make sense.
hang on a
to me.
second. Why didn't you write down that you delivered those?
Because that was already paid for and I'm not gonna carry 12-foot boards on a 5-foot bed all the way to Detroit and back. It does not make sense. When she has a garage and I can use her garage to storage the wood in there, which is in there. And then I pull it out, I use my things, I start burning it, stain it, let it dry, call it a day. I can't stain it because then the wood will warp in the cold. And I told her that.
And you say he never sent.
I never got the supplies, the 900 that he was given to do that work. I have no materials at all in my home for that.
her husband that allegedly has cancer.
All right, come on then.
No. Supposedly her son was the one with some sort of cancer. Now it's her husband with cancer. It just does not make sense.
I never said my son had cancer. My husband is not here with me today because he is dealing with issues from bladder cancer and prostate cancer there.
Okay. That's the one that you called an idiot and.
All right, come on.
No, I'm being, I don't.
All right,
I don't.
all right, all right. I want to come and see if the moldings are in the garage.
I know there's no moldings at my house.
I want to come and see if the moldings are in the garage.
That's fine, you're
I want to come right now. You okay with that?
right.
We're gonna all meet there.
Could I see, I'm missing a framing nail gun and a battery.
You're gonna
My
come.
tools were stolen.
We're all going. It's not far from here. Hang on. Listen, folks.
I am banned from her household, just to let you know.
Is there a PPO issued by a judge?
Yeah.
No,
Well, you just called them up and told them you didn't want it.
So when
I was trespassing.
when the police came to the home that night, they said, "You want him on the property?" I said, "No."
Okay. Well, you don't mind if I bring them there now, right?
No problem.
You don't have any PPO signed by any judge, right? So no judge, wait, just please listen. So nobody in the circuit court has told you or signed an order saying he can't be on the property, right?
No, you're.
Okay, here's what I'm doing. I'm meeting you guys there in 10 minutes. Don't open anything until I get there. You know where it is. It's at 2880 Long Meadow. Is that north or south of West Road?
My house sits right behind. Don't know.
That's
Southwest.
Yep. Okay. I'll be there.
Can I say something?
Now, folks, I gotta go. Hang on. I gotta go. I'm not making my decision today. You guys are coming back in a week. Give them a date, Jennifer, quickly, please. And make sure that all these pictures are copied. Okay? Give me a date, Jennifer, please.
Yes, you said 1 week.
Yes.
We can do.
Problems in last week, whatever this week.
Okay.
All of Mr. Burbank's.
Hold on, everybody. A foot tall set of case. It doesn't matter, but you're. Three of them?
Yes.
Kenneth Jackson. That's Tom Burbank. Dylan Banks. Todd LeBlanc. Well, that's, you don't have to go get him. He needs to be in here, not you. I'm not paying you to be a bailiff. You know that. Okay. He's gonna try to bill me. Dylan Banks, he's in jail. Raymond Peoples is pro se. And he is in custody. Eric Martin.
That's what he said.
That's Mr. Burbank. Brandon Charles, William Wilkerson.
Ready?
Okay, Terrence Moore. That's also Todd LeBlanc. Troy Howard, Mr. Wilkerson.
So.
That's 6. Is it just 6 cases or, yeah, 6 cases. Ready on that?
We could be, Judge, but we prepped for the murders.
Same thing with the state
Well,
judge. I think.
remember, the court gets to decide what goes. You want it on the trial docket, so you gotta be ready for anything, right?
Well,
James Franklin. Yeah, y'all ready?
I mean, I've got a bunch of conflicts this week, but I could be ready if we were forced to get.
Could be ready. Tito Means, John West.
You're right here.
Yeah,
I'll be ready except for no official Wednesday.
Say it again?
I have a procedure next week. Yeah.
Okay.
But otherwise, I mean, if push comes to shove, I can cancel that and move it, but if you need to.
Damon Porter. You are
That's okay, same thing.
Megan Wilcox.
Same announcement, Your Honor.
Huh?
Same announcement, we can be ready if they need to.
Quincy Taylor. That's your stuff.
Yes. Yes, I can be ready, Your Honor, if we need to be. That's not the same announcement at all. I have one more back on.
Okay, Jerome Neb, Joel. Where's Joel?
Just here.
Glover Jones.
First line,
And Jasmine. Yeah.
Judge, we're in talks about that one. I've cycled through a couple of prosecutors, but I'm hoping.
God bless you.
It is. I'm speaking.
Are you satisfied with the one now?
Yes, Judge, Mike has been very helpful.
How's that working out? Good?
She's working good, I think.
Michael Cup.
If you're on that, Your Honor, and we're ready. It's straight.
Rodney Wells.
Same thing, Your Honor.
Once again, that would be amazed here.
Your comments.
20 cases on the docket, no pleas. Everybody wants to try 20. Is that normal? No. Okay. Joel is first on the Senegal. And look, Dylan Banks will be Dylan Banks 2. And then Raymond Peoples is 3. And
Yes, sir.
Brandon-
We tried the aggravated assault peace officer on Raymond Peoples.
and we'll do 5 just to be in the, and then
I need you.
Terrence Moore is also a murder case. Okay. That's that. Tommy Beauchamp, Langston. Why is it being reset?
I think it's.
I'm not.
Reset, hold on, reset.
Still in Orange
What
County.
is-
Yes, sir. Yeah, it says on mine that he's still in Orange County.
Still in Orange County.
Yes.
Yes, sir.
Why is he hiding out in Orange County?
You want to get those off your desk?
Philip Bennett.
I think that's allowed that they wait on still. I got that on Mr. Ham, right?
Yes.
I contacted the crime lab on Fridays.
Yeah.
And they promised me that this blood test, there's some testing that needs to be done. That we're leapfrogging, put it in the batch, the next batch, it should be ready.
Yeah.
It's like a 4-week reset, which we could
How many?
4 weeks.
Is that right?
That's fine.
All right. Or what? Try?
Well, we just need to get the results back so we can make some decisions, Judge. And until we have that.
I just went through 20 cases where everybody wanted a trial, so.
Yes, sir, I understand.
When they don't want a trial, it amazes me. I'm shocked. It's an
These are
aberration.
MTRPs and it's subject to the testing before we can move forward, yeah.
So 4 weeks, we're gonna be ready to move forward one way or the other, right?
Could be.
Miranda Bolin.
Just can I have this one we said along with that's just all of it. Knock out and move out. Only one.
So the length of time, 3 weeks, good?
That's perfect.
Okay.
We'll make it work.
Reset on Bolin, 3 weeks. Henry Jackson.
That's another one, ones that I believe are going to allow on the, that's when you have to put.
Yes, we are still waiting on the labs.
And let's review it in 3 weeks, okay? So weird. Ronald Falls.
There's nothing you want to bring him out tonight, but I gave him all the police reports to look at and read. He's maintaining that it's not him, they got the wrong person.
But they all say that. Oh, it's an MTRP.
He's
right. No, Ronald Falls. No.
Yeah, I thought it was
Not MTRP.
It was a solid service. He's saying that the support got the wrong.
Oh, well, then there's nothing. that- Yeah, that's, first of all, this is going on 6 years old. He's a transient. That's, okay.
He was in Vegas. I think that's what he was.
Yeah, let's set it for trial. Okay, put that for trial, and on this one, accelerate it, please.
It's false. Yes, sir.
Ashley Bendy.
That's not me.
No, it's Burbank. Burbank. Jeremiah Corey.
Judge, that's gonna be a plea. I'm filling out the paperwork right now. Well, I was.
It's a pleasant change.
Two cases.
Two cases.
Of course, he got a new case and he didn't do anything.
Siku.
We're ready to next week.
Last 12 PM, a new case. Yeah. So he would know probation for this.
It's also going.
Failure to register, no, failure to register, and he didn't do anything.
But I can see where we are on this now, and I'll go right back to you.
What about you?
Lace Christian,
Hold on.
Ryan Gertz.
I think he's back talking to her, Judge.
Dennis.
Yes, sir.
Kaylin Hicks.
That's a weird, sorry. I think I'll be motion on the bill, if there's any motion. Yeah. Or it'll help the expert.
Okay. Let me come back on that here in a minute.
You mind for the next?
Go. Marlon Perkins,
Yeah.
Mr. Macon.
He's just here. Oh, there he is. Who, what? Marlon Perkins, that's that psychiatric. Started to say, he's not here.
No, he's not here.
Here.
Okay, Mr. Perkins, who claims to be, who? He claims to be someone other than him.
No, he just hears a voice, wisdom that tells him
I need more.
litany of things.
Yeah, I need more files.
Someone not like to mention on.
Here's the rest. So he believes in incest.
Yeah.
Yes.
So what do we do with Mr. Perkins?
So we commit him for another year. You have the doctor's letters.
Right, let me go through these other ones and then we'll come back to Marlon. God bless him. Yeah.
He's really a nice guy.
Home with you.
I'll let him go home with you. But you gotta
Giblin always.
take care of him.
You need to go home.
Damon Cantu, I'm not gonna put you in the right for that. Damon Cantu.
Judge, I just received an offer on him. I need some time to talk to him.
Much. Is 3 good?
I would prefer.
Why?
Only 42 days old, and plus I went through all of the information.
It's on the comply with sex offender registration. That's pretty simple. That's straightforward. William Gardner, what are we gonna do on William Gardner?
It's got to come up. We're not actually received the terror by. 3 or 4 weeks.
We got him on both. Those around.
From that, it's my understanding that Mr. Ham has put a rush on those results. We just don't have them as of right now.
Oh, we've been waiting a long time.
I think a couple of weeks, so it's a nice put a rush on them, so hopefully we'll be ready in 3 to 4 weeks, but I don't.
Xavier Kane,
Okay, thank you. For
that's 4 weeks on all those.
Okay.
Bruce, Xavier Kane. What are we gonna do on that? You need a hearing today on that? Yes, no.
Whatever you'd like to, you want to go ahead and set it for a hearing.
NTRP hearing? When can everybody be ready on that, please?
But I just received a second motion. A second bit motion to vote, but I haven't really had a chance to look at the offenses.
I just filed the motion on Friday, Judge. The amended motion.
It adds a new crime.
Yes, sir.
And location other than his residence. So that's a grand total of 8 violations alleged. What do you want to do here on this?
I'd like to have up him to look at the new.
How much time do you need?
The ones that were on Friday.
How much time?
30 days.
4 weeks good?
Yes, sir.
So 4 weeks. Cameron Hernandez. Yeah.
Or this one, it's NTRB, he has new cases incoming that has to file.
I don't care. Well, we're gonna move forward on the NCRB and then whatever happens on that.
We should be able to work them all out together. We're just waiting on the indictment. It's received right now. It should be indicted within the month. I can get specifics when I go upstairs. I don't have specifics right now.
Let y'all know, probation department wants to keep safety here, but we can't do that till the case gets resolved. That's what's. Then.
When you.
Well, no, not that. Was that pretty. That's no.
Was it on the phone?
No, it's on that job.
This alleges 4 crimes on my wall. 4 crimes on my wall.
It's just,
Dating back to like last year, July, theft, November, a theft. Let's see. What's the difference between 1 and 6 on this First Amendment and 1 and 2 and 7?
Yeah, the opposite.
they're different offenses, Judge.
They're the same date on each one, but the same crime.
I mean, that's already.
How are they different, please? I mean, they're different acts, what you're telling me?
1 and 6. 1 happened on July 19th of 2025. 6 happened on October 15th of 2025. 2 is a theft that happened on November 25th of 2025. And 7 is a criminal mischief that happened in 2025. So it's 4 separate offenses.
All right, where can we go on a hearing on that?
If you give us just a little bit of time to get that new theft indicted, we should be able to work
I don't
all
care
out
about
all
the
together.
Really, it's not that. These are motions to revoke probation. We can move forward without indictment.
I was the first mistake. We had to be ready. So,
Okay, 3 weeks, okay? Can we just? Thank you. So Cameron Hernandez. Jadrian Bob.
Hold that one, I'm working on that one.
Jorge Perez.
You know, that's one that was being evaluated. I have not seen a evaluation back in yet. Let's
see.
I haven't seen it. You may have it, but.
Me from Dr. Clifton.
It was one of them that we brought back out and reevaluated. I know we had one.
Yeah, I got something that was in January.
Yeah, very hard was success.
And then did we do something subsequent to that? Because I'm not looking at it.
It came out here on, he was not very, You're the one who said, let's do another IES because it's not making a lot of sense.
We don't have that. That's all I have is in January. There's another one that happened.
Yes.
Reset, we'll review in 3 weeks on. Jorge Perez, 1, 2 cases. Thank you. And Matthew.
I think your honor, this evaluation was not very lucid. We thought about last time.
I thought we had a report, but it was another yellow page.
Right, that's not Alvin is having.
All right, review in 3 weeks on Matthew Smith. Thank you. Yeah. Jeremiah Foray, Judge. 2 cases? Yes. They get Emerson Kelsey.
All right.
Maintenance.
This
Yeah.
Yes. Mr. Foray, you need to come stand in front of me, please. Raise your right hand. You swear or affirm to tell the truth, honestly, that the truth shall be God. Okay, you put your right hand print, right down.
We're doing cases.
Yes, one of them's a motion to revoke and then consider yes.
Thank you.
Place it right outside. Right, here's not a judge.
2 cases are now called involving Jeremiah Jean Foray. Is that you?
Yes, sir.
What's your name?
Jeremiah Jean Foray.
Jean.
Yes, sir.
Jean.
Yes, sir.
That's pronounced several different ways, but you pronounce it Jean.
Yes, sir.
And you were here with Mr. Dusler, your attorney, and the state's attorney. Does the defendant waive formal readings of this first amended motion to revoke unadjudicated probation and the new case, a 3rd-degree felony failing to comply with sex offender registration requirements? Can we proceed in summary?
Yes.
Let's take this new case, substantive case 26 CR 190. In summary, this indictment handed up by the grand jury on February 4th of this year alleges that on or about August 25th, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of failing to comply with sex offender registration requirements. Do you understand what you're charged with?
Yes, sir.
Explain now.
Okay. Just come back.
This is a 3rd-degree felony. If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty, sentenced to 8 years in prison to run concurrently with 23-41590, which is a motion to revoke probation that we're going to go to next. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. That's a yes
Yes,
or
sir.
no,
Yes, sir.
sir. Yeah. Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney?
Yes, sir.
Or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and
No objection.
without objection admitted. The states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. Know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true. It states so help you God. Correct?
Yes, sir.
States Exhibit 1, part of the record for all purposes, pre-sentence report.
Yes, sir.
I am going to follow this agreement. If nothing further, I'm going to find, sir, you are pleading guilty voluntarily. You are mentally competent to do so. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of failing to comply with sex offender registration requirements. I now find you guilty beyond a reasonable doubt of this third-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional divisions of the Texas Department of Criminal Justice to serve a term of 8 years. You understand what has happened today in this case, sir?
Yes, sir.
Let's go to this 22-41590. This is a motion to revoke, first amended motion to revoke probation filed on March 17th, 2026. Are we ready to move forward on this?
Yes, sir, we are.
Does the defendant waive a formal reading of this first amended motion to revoke probation from the preceding second?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing on this motion to revoke probation shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Yes, speak out so she can hear.
Yes, sir.
Okay, lower your hand. In summary, this first amended motion to revoke unadjudicated probation states that in this criminal district court of Jefferson County, Texas, on June 9th, 2025, last year, you were placed on 10 years deferred or unadjudicated probation for the second-degree felony of indecency with a child. Do you understand that is being alleged, and is that allegation indeed true and correct?
Yes, sir.
Yeah, if we just go to number 10, that's the new case.
Number 10, first amended, and this motion to revoke probation on the violations group 10 states that you committed the offense of failing to comply with sex offender registration on or about August 28th, 2025 in Jefferson County, Texas, which was a violation of condition 1 of your deferred or unadjudicated order. You just pleaded to that and you were found guilty to that. Is that allegation true and correct as it is alleged?
Yes, sir.
Are you pleading true and correct to this voluntarily and because it is true?
Yes, it is true.
Do you understand that a voluntary and truthful made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation in this case can now be revoked. You can be found guilty and sentenced up to the full range of punishment. A second-degree felony carries with it no less than 2 nor more than 20 years confinement in prison. Do you understand the consequences of this?
Yes, sir.
Knowing all of that, do you insist on pleading true today to this allegation of a violation of your probation?
Sir.
Find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. There is an agreement that's been reached where your probation would be revoked. You would be found guilty of this underlying offense of indecency with a child, and you would be sentenced to 8 years in prison to run concurrently with the previous case that you just pleaded guilty to earlier, and that's 26. Let's see. This is written wrong. It would be 26 CR 0190. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this allegation?
Guilty.
Are you pleading true as well as guilty? Voluntarily and because it is true as it is alleged?
Yes, sir.
Going to show you here what's marked as States Exhibit 1. Did you sign this document, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection and submitted. Among other things, this states, if I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
You just need to sign that right above on that council.
Yes.
Anything to add?
No, sir.
If not, I'm going to find, Mr. Forey, you are pleading true to allegation 10 of this first amended motion to revoke unadjudicated probation filed in this cause number 41590 on March 17th, 2026. You were doing this voluntarily, knowingly, and you understand and appreciate the consequences of pleading true. There's enough from your plea of truth to support this motion to grant it by a preponderance of the evidence is greater. This first amended motion to revoke unadjudicated probation is hereby revoked. It is hereby granted. And as to allegation number 10 and your deferred or unadjudicated probation earlier rendered in this case is hereby revoked. In that earlier case, on June 9th, 2025, when the court sentenced you to deferred or unadjudicated probation for 10 years, you had pleaded guilty at that time to this underlying offensive indecency with a child with second-degree felony. Voluntarily, you were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from States Exhibit 1 admitted in that hearing to find you guilty beyond a reasonable doubt. Now that your probation is hereby revoked, I hereby find you guilty beyond a reasonable doubt of this underlying indecency with a child, second-degree felony case as a placement probation plea. And I find you guilty, and you are hereby sentenced in accordance with this agreement to confinement in the institutional division prison of the Texas Department of Criminal Justice to serve a term of 8 years. This will run concurrently with the previous matter that you pleaded guilty to earlier today. Do you understand what has happened in these two cases, sir?
Yes, sir.
Anything else to add?
No, sir.
All right, we are in recess on these two cases. Thank you. You will be given credit for all time you have served in accordance with these cases. Thank you. Kita? Siku Kita? He's in custody. They're getting. Kita, K-E-I-T-N. We need. Okay. Just one case now? Yes. It's most remote. Anybody? Oh, you can. Yes. Days off. We now call 18-29291. We should know to the state of Texas versus, and pronounce your name, sir? 60.
Yes, sir.
And is it Rashad?
Yes, sir.
And then is it Keita or Keita?
It's Keita.
Keita. K-E-I-T-A.
Yes, sir.
You are here with your attorney, Mr. Boosler, and the state's attorney. As you know, you were placed on probation earlier. I'm not worried about it. It's 2018, almost a lifetime ago since and there is a fourth amended motion to revoke unadjudicated probation that has been filed most recently in all of these filings, January 16th of this year. Does the defendant waive a formal reading of this fourth amended motion to revoke unadjudicated probation? Can we proceed in summary?
Yes, sir.
Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Lowe's ends. We've come a long way in this case.
Yes, sir, Judge.
In fact, 27.
Originally, we started out with two cases, and you did a split sentence a while back to where he went to TDC. And then when he came back, then he got these, I think this probation continued on, and he got some violations after he got back out. I think he got back out March 25, I think is when he got back out from prison from the split sentence that you had.
Okay. There's a fourth amended motion to revoke unadjudicated probation. It just alleges 27 violations of probation. What do we got?
24 is sufficient, which is
24 to 27?
No, for 24, because that's the new possession traces, these ethanol traces.
Okay. All right. In summary, we can take this by summary. Yes. In summary, sir, this states that on August 3rd, 2018, in this court, you were placed on 10 years deferred or unadjudicated probation for aggravated assault, a second degree felony. Is all of that true and correct, sir?
Yes, sir.
Allegation 24.
Yes.
States that you committed the offense of illegal possession of controlled substance on or about October 1st, 2025 in Harris County, Texas. And I'm looking at the administrative hearing on that matter, and it is alleged that you committed the offense of illegal possession of controlled substance, which is methamphetamines.
And Judge, he
less than 4 grams.
He pled to that in Harris County, got 180 days, I believe.
Is that allegation true? Are you pleading true voluntarily and because it is true as it is alleged? You have to speak out so she can hear.
Yes, sir.
You understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation. Your probation can now be revoked. You can be found guilty and sentenced up to the full range of punishment. This is a second degree felony. You were looking at no less than 2, no more than 20 years confinement in prison. Knowing that, do you insist on pleading true today?
Sir.
You were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Looks like an agreement has been reached where you would be, your probation would be revoked. You would be found guilty, sentenced to 3 years in prison. Is that your understanding, sir? If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
Yeah, so show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence. Without objection admitted. This states, among other things, if I follow this agreement, you will have no right of appeal. You understand?
Yes, sir.
I'm going to do this and follow this. Anything else to add?
No.
If not, I'm going to find as follows that the defendant is pleading true to allegation 24 of this fourth amended motion to revoke unadjudicated probation, alleging he committed the offense of illegal possession of a controlled substance, and mainly in the record, this is methamphetamines. He has done this voluntarily, knowingly, intelligently. That isn't to grant a motion to revoke probation. by preponderance of the evidence or greater, it is so granted, and your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you had pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault. I now find you guilty beyond a reasonable doubt of this offense, and I am following this agreement, hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. The judgment shall reflect that a deadly weapon, namely a knife, was used in the commission of this aggravated assault. Do you understand what has happened today?
Sir.
Anything else? That is so Zero, Ricky?
Yes. Yeah. Zero. Thank you.
Ricky? Zero.
We're driving to our apartment because it's going through and then there's also stop. Right conference. The flat right down low. There's one more house on here. The flat right there. I feel safe by judge.
At this point, I'm out.
Once you get yourself. Whether he's on off everyone.
We now call clause number 26CR 20. The state of Texas versus Ricky Lynn Zero. Is that you, sir?
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment handed up on January 7th of this year by the Jefferson County Grand Jury states that on or about September 14th, 2025 in Jefferson County, Texas, you committed the third-degree felony of theft. Do you understand what you were charged with? It looks like involving an automobile of a value of $30,000 or more, but less than $150,000. Do you understand what you're charged with?
Yes, sir.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. Restitution would be owed in the amount of $350. There would be other terms and conditions of probation that are normal and customary for this type of offense, and the probation officer would go over all of that with you here in a minute. Is this your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to discharge, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence?
No.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All truths will help you God.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is away.
Yes, sir.
If nothing further by the parties, I will find as follows. You are pleading guilty voluntarily. You are mentally competent to do so. And you understand and appreciate the consequences of pleading guilty. And how do you formally plead to discharge, guilty or not guilty? I'm sorry.
Guilty.
I I find you are pleading guilty voluntarily, knowingly, and intelligently, that there is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of theft. I am following this agreement. We're hereby sentenced to confinement in the institutional division prison of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement in prison is suspended. You were placed on regular probation for 10 years. You must pay a fine of $500. There will be restitution owed to the complainant in this indictment in the amount of $350. There will be other terms and conditions of probation, which are normal and customary for this type of violence. Make sure you follow those. If you fail, the probation can be revoked. You can be sentenced up to 10 years in prison. How long will it be before you can pay for this $350 now? How long do you think?
After I get out, I think I'm
gonna give you 3 minutes. Okay, quicker the better. Also, you do well, you get this probation gets shortened to 1/3 of the time. Now, just 10 years, it'll be just 3 1/3. And at their restitution phase within 90 days.
Yes.
As a condition, okay? You can do that.
Yes, sir.
All right, anything else? No, that's all. Thank you. No.
Thank you. Judge, Talbot has a plea off the trial book.
Okay. On this Marquise Washington, there's a dismissal. Is there a plea that's going to be done on that?
No, Judge.
That's just a straight dismissal?
Yes.
Okay, 46 CR 671 is before the court. Marquise Washington, a motion to dismiss was filed and it is going. That case is hereby dismissed.
You have something on there?
And I've got 2 cases on Troy Cheek dismissals. Are there is there another case or are those just flat dismissals?
From a re-indictment, Judge, so those are be dismissed.
Okay, but we're not going to dispose otherwise.
No, sir.
All right, then 24 CR 499 and 24 CR 1016. Troy Delano Cheek, motions to revoke, motions to dismiss have been filed by the state, and each of those are dismissed.
There we go.
Which side's casing again?
It's on the trial book, Judge.
Okay, okay, they can come up. And 24 CR 1016, Troy Delano Cheek, motion to dismiss that case is hereby granted. That case is hereby just. Okay, who is it?
Dylan Bennett. I have the call right here. It was on the phone.
All right, we call now. House number 22 CR 34. It's, you give me Dylan Banks.
Yes.
Is that right? Is that yours?
Yes.
Oh, okay.
Short worker, so okay, right on front. Don't sit right in the box. Back one more time. Let's sit flat right there outside the box. Okay, the stand front of judge.
Okay. Mhm. Okay, you're Mr. Banks?
Yes, sir. Yes, Your Honor.
All right, 23 CR 34 is now called. The state of Texas versus Anthony Banks Senior. And you were here with Mr. LeBlanc, your attorney, and the state's attorney. I'm sorry this thing took long. I'm looking at this and, the files, unless they come to me and generally for a disposition, I don't look in these files because there's 5,000 of them. And this states it's something filed June 6th, 2 years ago, that you wanted to take your case off of the trial docket and sign for us an agreement for this case and dispose of this case. And I don't know why that.
Not to worry, Judge, we didn't actually come to terms till today.
Okay, well, his agreement is different from what the agreement was. His proposal was something different.
Yes, sir.
It was far less than what ended up being the agreement. And it was kind of sent to me, but of course I can't make deals with you directly. That's between the lawyers and all right. So does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
Yes, sir.
We're only going on paragraph 1.
Yes, sir.
In summary, paragraph 1 of this indictment alleges that on or about January 13th, 2023, in Jefferson County, Texas, you committed the first-degree felony of injuring, causing serious bodily injury to a child 14 years of age or younger. Do you understand what you're charged with here, sir?
Yes, sir.
This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced to 35 years in prison. You'll be given credit for all time you've served in accordance with this case. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not?
Yes, sir.
Are you pleading guilty voluntarily? That is on your own free will, and because you are guilty. Let me please thank you. Please look at what I'm showing you. State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read through. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, consultation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyers. All of this is true. It states, so help you God. State's Exhibit 1 is made a part of the record without objection for all purposes in this case. Is a pre-sentence report waived? I am going to follow this agreement. If nothing further, I'm going to find Mr. Banks, you are pleading guilty to this first-degree felony of injury to a child 14 years of age or younger, voluntarily, knowingly, intelligently. This is a first-degree felony. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at this hearing to now find you guilty beyond a reasonable doubt of this first-degree felony of injury to a child. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 35 years. Do you understand what has happened today, sir?
Yes, Your Honor, I do.
what's the status of the child now?
She's still suffering.
From
From
the
the
effects
injury.
of this offense?
There'll be lifelong injuries for her.
I mean, it's serious bodily injury to the child. Is
Yes,
what
sir.
it's, result of it. All right. Do you understand what's happened? Yes?
Yes, sir.
Anything else to add? No, we'll hear and assess on this case.
You're gonna let her go? Okay. And there's gonna go for park life and then we take them over, so all this. Sure.
Okay, so we've got, number one again is Xavier Senegal for trial. Two, God bless you. Two is, Dylan Banks.
No, we just flood that, Judge.
We just pled injury to a child. So that is, Raymond Peoples is now number two. I don't know what happened on that. But anyway, Raymond Peoples is now number two. And then three is Brandon Charles. Four is Terrence Moore.
Always try to do that. If not, I'm gonna do it. I'm gonna get it. It's not me to pull it.
Okay, I think that's everything off that trial docket, right?
Yes, sir.
Thanks, Christian. You're right.
For Ryan, you gotta get that done.
In the bag.
On Marlon Perkins?
Yes.
Do we need him out?
He's not here, Your Honor.
Oh, he's not.
Unless he's filed a waiver. Out with him May 1st on Friday, he stands on the waiver. He doesn't want to be here.
He doesn't? Now he knows that we offered.
Yeah. He's happy at his job at Rusk and
Isn't that nice? That's a good thing, I guess. Does he still
he's still,
feel as though he is God?
No,
our creator.
he's not really God. He's
That's
just
what he
someone
said, hadn't it, for years?
The wisdom, the voice tells him things to do and they're bad.
When you run upstairs with some people, get a call from them, just phone them. And keep going.
All right. Then in clause number, I find this 71463, the state of Texas versus Marla Perkins. Mr. Perkins was indicted in 1996.
Yes.
30 years ago for the first degree felony of murder. And was that his wife? Who?
His mother and I think his mother and brother were both killed.
By shooting his mother and killing her with a deadly weapon, namely a firearm. And Mr. Perkins has been pretty much institutionalized now over the long term, being placed in Rusk State Hospital, where he still resides. There is an updated report dated April 23rd, 2026. Have the parties had an opportunity to review this? Are there any objections or changes for this being part of the record for this hearing today?
No.
Not from the state, Ron.
All right. And it is a cover page from Dr. George Howland, physician, unit psychiatrist, Rusk State Hospital, as well as Matthew Gallagher, superintendent at Rusk State Hospital, which in summary state that Mr. Perkins was admitted to Rusk State Hospital under the provisions of Article 46C of the Texas Code of Criminal Procedure, pursuant to a finding by this court that the defendant is declared not guilty by reason of insanity. And after a period of observation and treatment, the defendant has been evaluated by the authorities at Rusk State Hospital, and it's the facility's recommendation that further hospitalization is indeed indicated at this time. Under the provisions of Article 46C of the Texas Code of Criminal Procedure, a hearing for the patient must occur before the expiration date of this present commitment, and we are holding this at this time, that hearing to determine what should occur next. And there is, along with this letter from Rusk State Hospital, a forensic psychiatry report, which is consistent on signed by George Howland. And with that report, a physician's certificate of medical examination for mental illness. Also signed by the examining physician, Dr. George Howland, both these dated April of this year. And I'm going to call each of these court's exhibits. The letter will be 1, the forensic psychiatry report shall be declared 2, and the physician's certificate of medical examination for mental illness in this matter shall be 3 on this date. Any objection?
No objection, John.
No objection.
Then states, courts exhibits 1, 2, and 3 are admitted and made part of the record for all purposes in this hearing. All right, any additional matters that the parties want to add?
No, Your Honor. No, Your Honor, like I said, on May 1st of this year, I spoke with Mr. Perkins. He reiterated he waived his appearance and did not want to appear for it. And had no additional information. He still suffers from hearing wisdom instructing him what to do, and he believes in numerous other things incest.
Jury 1, approach the jury. Jury 2. This is left law check, left law. Left law check, check 1, check 2. This is the right law check, check 1, check 2, check. This is the podium check, check 1, check 2 at the podium, check. Everything's working like it should. For the profile.
Which have made relationship with his daughter difficult. But other than that, he's a really nice guy.
On I'm looking at 2 cause numbers, and we have 2 cause numbers we're dealing with, correct?
Yes, 2 cases.
It's cause numbers 71463 and 71464. And
Correct.
71464 is murder. 71463 is what?
Murder.
Murder is also
Yes, sir.
an additional murder indictment that was handed up. And
So we're asking out the same.
and these matters of courts exhibits 1, 2, and 3 are to be part of each of these 2 cases without objection, correct?
Correct, Your Honor.
And again, this is applicable for both cause number 71463 and 71464. All right, based upon this hearing and the exhibits admitted into evidence, courts exhibits 1, 2, and 3, and these 2 cause numbers 71463 and 71464, the court will find that pursuant to Article 46C of the Texas Code of Criminal Procedure and the Texas Mental Health Code, the hearing was hereby conducted to determine if Marlon Perkins continues to meet the criteria for involuntary commitment. And the parties agreed from the documents submitted here that he does continue to meet the criteria for involuntary commitment, correct, everybody?
That's correct.
Mr. Perkins was found not guilty by reason of insanity for the two offenses of murder in 1999 in these cause numbers 71463 and 71464 in this criminal district court of Jefferson County, Texas, and was ordered by the court to enter into extended inpatient mental health commitment with the Texas Department of State Health Services, for which we renew annually. And in this hearing, the defendant waived his right to be present according to his counsel and did not request a jury trial on these issues, but instead agreed that this case could be heard and without his presence and a jury. And we have done this morning. The evidence includes the affidavits of Dr. George Howland, the attending physician to Mr. Perkins, and a report by Dr. Howland opining that the defendant is still very psychotic and recommends that he continue to reside in the Hope Residential Unit at Rest State Hospital for further treatment. We're going to, well, there are no objections to that finding being made, and the court will so find, as this court finds by clear and convincing evidence, that Mr. Perkins continues to suffer from schizophrenia disorder, bipolar type, also cocaine, which was a result of cocaine dependence, alcohol abuse, cannabis abuse. The court finds Mr. Perkins to continue to be mentally ill, and by clear and convincing evidence as a result of his present illness, he is likely to cause serious harm to others if released. And the court also finds that as a result of his present mental illness, if not provided with mental health treatment in an inpatient setting, he will continue to suffer severe abnormal mental, emotional, and physical distress. Thus, the court finds that without continued inpatient mental health treatment, he will experience deterioration of the ability to function independently. And as a result of his illness of schizophrenia, he is presently unable to make rational and informed choices as to whether or not to submit to treatment. And it is clear and convincing in evidence presented that his present mental health condition is expected to continue for more than 90 days. Therefore, it is hereby ordered, judged, and decreed that pursuant to Article 46C.261 of the Texas Code of Criminal Procedure, that Mr. Perkins' treatment is hereby renewed. He will continue to be ordered to be committed inpatient with mandatory supervision and treatment at Rusk State Hospital or at any inpatient hospital deemed appropriate by the Texas Department of State Health Services. And this will be for a period not to exceed 1 year. And this order is hereby made on this date, 4th, 26, and it will be memorialized in a written order. Anything else?
Nothing else.
Thank you. That's all. What else do you have?
Nothing else.
Oh, do we have any other pleas? John, you had something, didn't you?
One left hour.
Who is it?
J.J. Manning Bob. That's not going to be a plea, Your Honor. Yes.
read and write English?
Yes, sir.
Are you under the influence? While
realizes and appreciates.
And that he's killed the water and power and everything else to the trailer.
Regardless, how are they supposed to come back with no?
According to the report, he's been released and found competent, but he is not making any
Where is he?
sense. He's in jail. So I'm going to request another evaluation because he cannot talk to him.
Okay, do you fill that out? Can you prepare a quick written?
Yeah, I'm going to do that today. Yeah.
Okay.
Yeah, and then and we'll see what happens.
Okay. Cool. Ryan, what did you have? Okay, what are we going to do on this? Okay.
You can follow the plea agreement.
Sentencing hearing and.
This was filed, in Lace Christian's case this morning.
Did you?
12:45, yes. 12:45, another case.
Lace Christian, the matter of Lace Christian is hereby called. Two cases, 22-40354 and 22-41222. Lace Christian. Guilty.
Yeah, she got some solos on fallback.
223. And this shows she pleaded guilty on February 23rd. I don't have February 23rd, 2026 here on my screen to refer to.
Just we may have already processed the plea papers.
Also a little confusing, Judge, because she had two different sets of cases that are unrelated to each other with two different lawyers. So that may be creating something else as well.
Okay.
But
There is another case. So we have two murder cases here.
Yes, Judge.
On different dates.
Yes, Judge. And we're.
Okay. I do have on 41222, I've got nothing here.
That's what the 1245 is for.
1245 goes to that, Judge. She's admitting to committing that one, but she pled to the other one.
Is this you?
Yep. Yes, Judge.
Okay, I didn't. I can't come to, thank you.
If I had a cool name like John B. Stevens, I would write it all out.
But you said there was another lawyer involved.
There's
There was a sexual assault of a child that she also pled to. It's already been
We don't need
sentenced.
any other lawyers to be here this hearing.
She's already been sentenced on that one.
You're handling both of these.
That's correct,
independently,
correct.
Indicted murder cases
Yes,
on this lady.
Correct.
What is our master plan?
We're asking you to follow the agreement.
Which is a cap of 4 years.
Correct. There's a fun stuff in the pre-sentence report, but it's okay. I think she covered it in the second memorandum that we were having trouble with her accepting responsibility, but she did, I think, in the second memorandum. And
In each of. Okay, this states. This states though that 41222 will be dismissed.
Yes, but you're considering the 1245 allows you to consider the punishment for it.
Okay.
But
I just
yes, sir.
wanted to make sure.
Yes,
that
sir.
There's not going to be, there will be dispositions, but one guilty disposition, one dismissal disposition.
Correct.
We call two cases, 22-40354 and 22-41222. The state of Texas versus Lace Christian. That is you?
Yes, sir. Yes.
Present with Mr. Gertz, your attorney, and the state's attorney. Earlier, you pleaded guilty in cause number 22-40354 to the first degree felony of murder, which alleges that you shot the complainant with a deadly weapon, namely a firearm, killing the defendant, the complainant, and that this is a first degree felony. And a pre-sentence report had been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? State of Texas?
Not from the state, Judge.
And defense?
No, Judge.
Then it's made a part of this hearing for all purposes. Now, the agreement is whatever sentence shall not exceed a cap of 40 years imprisonment. So we are looking at no less than 5 nor more than 40 years confinement in prison.
Yes, Judge.
And is deferred or unadjudicated probation even on the an option?
No, because of the nature of the offense, Judge.
And regular probation is certainly not as well.
Correct.
So it is a flat time issue.
Yes, Judge.
And one other case, 22-41222, that will be dismissed as part of this agreement, but the court can consider the facts under that case in making its decision of the sentencing in this cause number 40354, and 41222 is an indictment handed up for the first degree felony of murder. Okay. State of Texas may open and close. Go ahead.
Judge, of course, we're asking for the 40 years. There's 2 homicides that she has admitted to. One that she pled guilty to, one she's admitted to in the 1245 that she also committed that one. So with 2 murders, it's easy to say 40 years is kind of light, but due to the circumstances of everything we looked at and talked about, and the fact that she's kind of accepted responsibility. I'm going to get into that. The problem I have with this whole thing is when she first did the pre-sentence report, she tried to go away from not taking responsibility. She didn't want to take responsibility for this homicide. Then she cleared it up. And when she clears it up, then she comes back and tries to blame it on her friend who has never met this man. She says that this man, Russell Rito, pulled his penis out and tried to get her to do things. And so they ended up shooting him, killing him. But when this man was found, he was sitting in a easy chair with his hands folded, fully clothed, not looking like he had even moved, and was shot while he was actually sleeping on the easy chair. And unless she took the time to try to dress him back up and do all the things to cover up what had happened, which doesn't make sense if that's the reason why she's saying she killed him. She also lied to the police whenever the police started talking to her about whether she'd gone back over there again. We have surveillance video and also her GPS showing she went back over to the house again with her friend to go take a cell phone back and to check on things. The next day, she says she went and tried to check on her grandfather, acting like she didn't do anything, knocking on the door. She said she knocked on the door to see if he was there, and he wasn't there, or didn't answer, so she went to the neighbors. But when you watch the videos, she gets out of her car and never goes to the door to knock because she knows he's dead. She goes and talks to the neighbors, acting like she never knew anything had happened. When you look at everything this woman has done in every one of these offenses, she has lied to every moment. She has done everything. The only thing she's telling the truth about in this court today is going to be that she actually shot him and killed him. That's it. And I don't care about the motive. I don't care about anything else. She's admitting to doing it. And so we're asking for the 40 years. And she also admitted on Lonnie Scott, who was an Uber driver that she had a one-time sexual encounter with, and then she's admitted to actually killing him also. So we'd ask for the 40 years. I don't think there's anything less you can give her.
Judge, we want the court to just follow the agreement at this point. Candidly, Judge, my client has struggled. She's had a lot of difficulty in her life and has trouble trusting people. And I think that has yielded a number of times in dealing with the police and the probation department where she has not been forthcoming in a way that she has been with me. But what I can tell the court is she has now in the sexual assault cases and now in these cases is here accepting responsibility, and we want the court to follow the agreement, please.
All right. Did you want to say anything, ma'am? No. Okay. So I want to just be clear on a criminal history. We've got this previous aggravated sexual assault of a child conviction, correct?
Yes, Judge.
And this was a sentence that occurred just recently?
Correct, Your Honor.
Where she received 12 years imprisonment, and this was an offense that had dated back to 2014, correct?
Yes, that's correct, Judge.
The court has reviewed the pre-sentence report and a recent memorandum supplementing this report submitted by the Jefferson County Probation Office. That was performed at the request of the defense, which asked for a supplemental due to statements that she had made during the interview. And then there is what happened the day of the offense. And I'm going to ask from probation, is probation officer here? That it was.
The author's not here, Your Honor.
Okay. All right. Y'all have read it.
Yeah.
And there was some concern about the defendant pleading guilty, and then in her explanations of her version of the events, seemingly not admitting responsibility for this.
Yes, Judge.
So that was from the original pre-sentence report. So we supplemented this with a follow-up.
Yes, Judge.
And then in this report, the way I read this, I'm still confused. It seems like she continues not to accept responsibility. That someone else is the one responsible. Can that be explained for the record? Because she's pleaded guilty under oath.
She has.
And I think we made it clear and methodical, but it's as though she's pleading guilty but I'm really not as guilty as you might think.
But as the court knows, when you have these types of offenses, one of the things is that people get charged even as parties, and they don't have to be specifically said as a party or anything else. I'm not saying that's what's happening here, but I am saying that had we gone to trial, she is well aware that she was present, she participated actively, and I think she's having candidly sort of a mental block about really saying I'm the one that pulled the trigger. But the reality is, Judge, that she is accepting responsibility through her plea and in recognition that she would be convicted as a party at worst, even if those events are somehow how she described. So
is all of that true, what he's saying?
Yes.
You understand? What I understand Mr. Gertz is stating, and in the legal way he does things, which is a good way, and an appropriate way. You have pleaded, the fact of the matter, you have pleaded guilty. And I ask you, when you pleaded guilty under oath to murder, are you pleading guilty voluntarily and because you are guilty? You said yes. And do you understand that someone can be guilty of murder by willingly participating in the act of the murder?
Yes, Your Honor.
And you admit that you at least did that.
Yes, Your Honor.
And you did that voluntarily, knowingly,
Yes.
and accept responsibility for being part, if not completely responsible, at least being part of the responsibility as a party to the offense, as the law states, parties to an offense are culpable or can be held responsible under law.
Yes, Your Honor.
All right. Anything else to add by anyone?
And Judge, part of that, it's just there's shame and embarrassment and things like that when you do something that you shouldn't have done and you know you shouldn't have done them. And so I think that's just one of the challenges that people have as a natural human reaction here. But again, we're asking the court to just follow the agreement and accept her acceptance in the form that it comes, and asking the court to follow the agreement.
Anything else? Anybody? If nothing further, then Lace Christian, I'm going to find you have pleaded guilty to this first-degree felony of murder voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1, admitted at your plea hearing, to find you guilty beyond a reasonable doubt. And your culpability has been supported as well by the findings from this hearing that you admit to being a party to this offense voluntarily, knowingly, intelligently, and being responsible as a party to this offense, which resulted in the murder, the homicide of a human being. You took an active role in that to make that occur. Correct?
Yes, Your Honor.
I now find you guilty beyond a reasonable doubt of this first-degree felony of murder. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. The judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this offense of murder. Anything else to add?
Judge, I do have family members from the 1245 that would like to make a statement as an allocation.
Okay. And we're talking about section 12.45 of the Texas Penal Code, which allows her
in the jury box, or do you want over here?
She can be right there. That's fine.
You want her to come sit at council table with me?
Yeah. We're section 12.45 allows evidence that other bad acts or crimes can be considered in the disposition of a case if proven beyond a reasonable doubt, which the court finds in this case that the defendant voluntarily, knowingly, and intelligently either committed murders individually or as a party to this offense under law, makes her culpable as either a principal or a party to this first-degree felony of murder. All right, go ahead. And please introduce yourself so the court reporter can know.
Good morning. My name is Sarita Rice. I'm the sister of Lonnie Dean Scott. I'm sorry, I'm nervous.
And for the records, the sister of
The victim of the
1245, Judge.
Okay.
I'm the sister of Lonnie Dean Scott.
We have two victims here in these.
The cousin of Russell Rito.
Okay, so you're related to both
Yes,
victims then. A cousin to Mr. Rito, for which the defendant was sentenced here, and then you are a sister
of Lonnie D. Scott.
in the other, this is 4122, which was the other murder.
Yes.
That the defendant was held accountable for. Go ahead, please.
I promised myself I wouldn't get up and cry. These type of things you can never prepare for. I don't want to be up here alone. Being here is torture enough. You were my first. I don't know you, but you were my first. And when I say you were my first, you are the first time that I ever in my life, I'll be 53 years old on the 14th of this month. You were the first time ever in my life that I had to bury anybody. My mother had 6 kids and adopted 2. That's a total of 8 kids. All of us are grown. My mom had all her kids until you took my brother. I don't know what you told these people, how you felt about my brother, but I'm going to tell you who my brother was. He was not a victim of recidivism. I looked up his file. Last time my brother was in trouble was in 2008 for a marijuana case, less than 2 grams of marijuana. He liked to smoke his weed. But let me tell you who my brother was. My brother had been in prison 3 times. For drugs, not selling drugs, for being on drugs. He had a problem. If he never raped nobody and he never killed nobody. When my brother got out, he got his act together. He started attending classes. He was a foreman. He got certificates. He even became a business owner of his own transportation business. I had all the paperwork packed up to go. But when I went to pick up my sister up, I left it there. And I believe everything happens for a reason. But my brother had his own transportation business. He was an Uber driver. He was so excited about being an Uber driver. He would get up at 3 o'clock in the morning and drive to Houston Intercontinental Airport just so he could, that was his favorite place to go because that's where he made the most money. To go pick up people and bring them to their job, to back here to Port Arthur to the port. He was the taxpaying citizen. He went from going to prison 3 times to changing his life completely. You know what else he did? He became a homeowner that my family is benefiting from. Yeah. He became a homeowner. Legally the right way. He went to work every day. And he saved up his money and he bought a home. Something he never did in his life. He was proud of his life and we were proud of him. He was a family man. He was. We would all get together, do karaoke. He would sing, he would dance. He was not the Lonnie Dean Scott that went to prison 3 times years ago. He was a new, revised citizen Lonnie that all he did was just worked, went home, you know, did what he liked to do, but he never bothered nobody. Well, my brother messed up is that he trusted you, just like Russell trusted you. And you took advantage of that. You took advantage of him trusting you. He was a single man. You knew he was an Uber driver. You knew he had cash money. I don't know what your motive was, but you knew exactly what you was doing. You did it. You did it, and you need to take responsibility for what you did. You killed Lonnie in cold blood, and you killed Russell in cold blood. You are a serial killer. A person that kills a person 2 or more times within a cooling period. Only God knows if that was the only 2. But we're going to speak about what's facts. You killed my brother in cold blood. You wasn't fighting for your life. He didn't try to rape you, doing him wasn't in there fighting. That do none of that. Because you know how I know? I seen how you came into his house. My brother was asleep on his recliner. I started to wear the tennis shoes because you know what else we had to do? I had to do, thank you for my first again. I had to go clean up his house. I sure did. The blood that seeped through his couch on his floor, I had to see that. I had to get that up. The blood matter that was on that pillow that you used, that you put on his head and shot through that pillow so nobody wouldn't hear. I had to get that up. I had to clean this whole house up. You did that, and you need to take accountability for what you did. You are who you are. You're not going to change, in my opinion. You are a menace to society. You have hurt and ruined so many families. You have hurt and ruined so many families. My mom is 76 years old. She never lost a kid in her life. Until you decide to take up on yourself and murder. You didn't just stop with 90. You went to Russell and whoever else. And you know what? You didn't stop on your own. You got stopped. You got stopped. So you can sit up here and tell these people whatever you want to tell them. But I know, and everybody else know, because pull off the smiles. You stopped because you got caught. Killing 90 wasn't enough for you. You went on to Russell, and whatever happened between that, don't nobody know. Only God knows. But you are who you are. You've hurt my family. My family is still hurting. I've been on depression pills. I've had loss of sleep. I've had to bury my brother. Me, the baby girl. I have a son. No parent wants to bury their son, their child, whether it's a son or daughter. Should I have to have that responsibility? No. But my mom came to me and she said, Sarita, you're going to have to do it. I can't do it. At that time, I had surgery. I had a femur broken on my left leg where I have a rod in my left femur right now. I had to throw my crutches to the side because I was on crutches at that time. I had to throw my crutches to the side with 32 staples and do what needed to be done. I couldn't say no to my mom. I had to do what needed to be done. You did that. That's something I would never forget. I can't get the vision out of my head what I saw in that pillow, what I saw when I went in that house. After the crime scene, people came and told us we can go leave. I don't know what his wife saw. I'm pretty sure the same thing his side of his family saw. But you know what I know that people didn't see? Your family didn't see what we had to see. So your family can still call you, come visit you, talk to you, write you. You can still go to the day room and laugh and play dominoes or play cards and make soups, make spreads. I know how they work. I did 10 years at TDCJ as an employee. So I know how they work. I don't hate you. I hate what you've done. I don't think that you're good for society at all. I think if you get out, and when you get out, you're going to do the same thing. Because you didn't stop, you got stopped. You didn't feel bad about what you did. You didn't have any self-conviction and say, let me turn myself in because what I did was wrong. You didn't. You didn't call after you shot my brother. You didn't say, oh, I feel so bad. Let me call the ambulance. You didn't do anything. When I got my brother tennis shoes that he had on, they were still warm.
Dr. Russell, the court will find that the defendant is now competent to stand trial. We're going to set this out for 2 weeks for a further pretrial, correct?
Yes,
that's correct. Mr. Aldridge, you've executed a limited time waiver.
I have. I'm going to fill in the date once I get that scheduled.
Okay. Anything else from the state?
No, Your Honor.
Anything from the defense?
Nothing else.
All right, very good. I'll see you all in 2 weeks.
Okay. I'll be over next week or so.
08 CR 24940, the state of Ohio versus Antonio Cabrera. Ms. Nicholson, the court has received a nollie signed by Assistant Prosecuting Attorney Steve Knippen.
Your Honor, we'd ask the court grant that nollie.
Anything else for the record?
I do not have anything else.
All right, then the court will grant that nollie. Is Mr. Cabrera in custody?
My computer is restarting, so I will check and let Mr. Logston know if that's an issue.
All right, if he's in custody, he's to be released immediately. All right, thank you. Are you ready?
Yes, Your Honor.
Case number 25CR43270, the state of Ohio versus Joshua Fritz. Mr. Fritz is before the court with his counsel, Mr. Valles. Ms. Nicholson, on behalf of the state of Ohio, we're here for sentencing. There was a pre-sentence investigation that was completed. Has everyone had an opportunity to review that?
Yes, Your Honor.
All right, anything on behalf of the state?
Your Honor, we'd ask you adopt the agreed recommended sentence of 36 months total in prison. There are 0 days of jail time credit.
Anything from probation? Mr. Valles?
Your Honor, just in statements of mitigation, that being, sure. Mr. Fritz is just 31 years old. Prior to this, having no felony record or conviction of any sort, he is a dedicated father, partner, and son. In addition to our arguments in our sentencing memorandum, I'd like to just bring to the court's attention that Mr. Fritz, when confronted with what had occurred, he only told the truth to the investigators. He admitted what he had done and why. The why was preparing for a family, having money issues, not to fuel any sort of addiction or to settle some sort of debt. But those reasons don't change what occurred, but it puts into perspective why a young man with no record prior to this ends up with the felony conviction. He was enlisted previously in the military, but due to the present matter had to abandon that. But just want to acknowledge an honorable thing to do is to defend our country. So I applaud him for that. Mr. Fritz intends to make use of his time. And at the time, have the court consider a judicial release at the appropriate time. Would ask the court that in consideration of the plea agreement, as well as the financial status of Mr. Fritz currently, we'd ask the court not to instill a fine at this time. Thank you, Your Honor.
Thank you. Mr. Fritz, is there anything you'd like to say?
Yes, Your Honor, if I may have the opportunity to speak. Excuse me.
You're fine.
I want to start by thanking you for the time to speak today. I want to begin by taking full responsibility for my actions. I will not excuse what I did. I violated the trust that was placed in me, and I failed to uphold the standards expected of me, both professionally and personally. What I did was wrong, and I accept full accountability for the harm I caused to the institution I served, to my coworkers, to my family, and to the community. At the time, I was under heavy financial and mental pressure. I was going through a separation and was seeking to finance a divorce, while also trying to provide consistently for my daughter from that relationship and prepare for my newborn son who was on the way with my current partner. My girlfriend had lost her job and had been unemployed for a few months leading up to my offense, which made me the sole provider of our household. And I also took on helping cover her debt to her home after she moved from Obetz, Ohio, to live with me. The cost of living had been unforgiving, and bills were constantly overdue and piling, leaving me overwhelmed and struggling to keep up with them. I have always had a habit to try to shoulder everything on my own rather than ask for help. And during that time, that mindset made things worse. Instead of reaching out for better solutions to help navigate through these pressures, I chose to continue trying to carry everything alone. I did try to make extra income the right way, door dashing, signing up for overtime when it was available, but those opportunities were not always guaranteed or consistent in my case. And behind those efforts, I made a serious mistake. I chose to engage in unlawful conduct by bringing contraband into the facility, something I would have never imagined myself doing ever, but I did. And I take full responsibility for it. I allowed desperation, stress, anxiety, and poor judgment to guide me. And I deeply regret that choice. Since the time of that regrettable decision, however, I have taken proactive and positive steps to change direction in my life. During the fall of 2025, I enlisted in the United States Navy because I desired structure, discipline, and a way to rebuild myself with integrity and to atone for the mistake I made. I wanted to commit myself to something greater and began correcting the path I had taken. During boot camp, I was taught the Navy's core values of honor, courage, and commitment. I was also selected as the Master at Arms for my division, Division 076. That responsibility required accountability, leadership, and discipline, qualities I am now working to fully live by every day. My daughter and my son are my biggest motivation to continue to be better. I want to be present in their lives, to provide for them honestly and consistently, and to set an example that they can be proud of. I regret deeply that my actions have put that at risk and caused pain to the people I care about and to my community. Your Honor, I respectfully ask for leniency in my sentencing. I am asking for probation community control sections so that I can remain an active provider and present father in my children's lives, as I have been since my return from boot camp in January. I am not asking to avoid consequences. I accept them. I am asking for the opportunity to continue moving forward, to support my family, and prove through my actions that this mistake does not define who I am as a man. Thank you for your time.
Thank you, Mr. Fritz. Mr. Fritz, you do understand that at the time that you entered your plea, Mr. Villegas has done an excellent job in getting this negotiated down to an offense that was not mandatory prison. You understand that?
Yes, Your Honor.
However, when someone enters into a plea bargain of this nature, where they're going from a mandatory prison sentence to one that is discretionary, but yet there's a recommendation that the state is making this amendment on the condition that you be sent to prison, at least for some period of time. The benefit to you is whatever your sentence is, I don't have to keep you in prison for that entire sentence. So it puts judicial release on the table. And that's what's been negotiated by your attorney, and that's what I intend to do. You understand that?
Sure.
So even though you're eligible for community control, you're not going to get community control because that's part of the plea bargain process. Had you not accepted this plea bargain, then whatever number I selected today to send you to prison for, you would be required to serve that entire prison sentence. Now you have the opportunity to pay the consequences of your misdeed and then to get out much earlier than you would have otherwise. Do you understand that?
Sure.
You're not getting community control today, okay? The court has considered the statements made here today, the purposes and the principles of sentencing, their relevant seriousness, and recidivism factors. The court has reviewed the sentencing memorandum of the defendant and the pre-sentence investigation. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So I'm going to order you on count 1 to serve 36 months in prison, on count 2, 12 months in prison, and count 3, 12 months in prison. Counts 2 and 3 to be served concurrent with count 1. You have 0 days jail time credit. The court will find that you're indigent for the purpose of any fines, costs, or other financial sanctions. You're also subject to a discretionary period of post-release control, which means that if you serve out your sentence, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision if you're sentenced to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. You have any questions for me before I give my final thoughts?
There's no way.
And again, here's the problem. I understand what you want, and again, your attorney fashioned this plea bargain so that you were agreeing that I was going to send you to prison. But my final thought is that you don't have to stay in prison for 36 months. You see, had you been convicted of the original charge, whatever number I selected to send you to prison for, whether it was 12 months, 24 months, 36 months, whatever that number was, you would be required to serve that entire time. Do you understand that? Now, I certainly appreciate family and friends being here to support you. And again, it breaks my heart because you're not the type of person that I expect to see in my courtroom. That being said, there is hope at the end of this. Hopefully, you have learned an invaluable lesson for the rest of your life, that there are no shortcuts. You can't take shortcuts even to make a buck here or there. You want to provide for your family. I support that. I will consider you for judicial release after you've served 6 months, because that's what the agreed recommended sentence was. Okay? So when you go up there, you keep your nose clean, you keep to yourself, you stay out of trouble, you follow the rules of the institution wherever they send you, you behave yourself, no write-ups. Then 6 months, Mr. Villegas will file a motion for judicial release. And if all of those things happen, it's my full intention to grant that motion and to release you into community control. We understand each other. Okay. Ms. Nichols, is there anything else?
No, Your Honor.
Mr. Villegas, is there anything else, sir?
No, Your Honor.
All right, Mr. Fritz, best of luck to you. Right now, there's a deputy standing behind you. He's going to take you into custody. You are remanded into the custody of the Warren County Sheriff for transport to the Department of Corrections, and I will see you in about 6 months. Dina, there's an exhibit.
Court does call the case of the People versus Wardell Smith.
Rob Dowd, Assistant Prosecuting Attorney on behalf of the people.
Good afternoon, Rob G. Kill on behalf of Mr. Wardell Smith. Wardell, would you state your name for the record?
Yes, Wardell Smith Jr.
Thank you.
Judge, today's time of day for a pretrial on this matter. Can we set this for a final settlement conference?
All right. Jury final settlement conference will be set June 5th, 2026 at 8:30. Jury selection, at 9 a.m.
Jury selection, if necessary, will be June 8th, 2026, 8:30.
Judge, what was the first date? I apologize, you cut out.
June 5th.
All right, thank you.
All right.
There's a chance that Ms. Zenda will be refiling the assault, great bodily harm with the murder, but I won't tell the court if that happens.
All right. Very good. All right. Thank you.
Wardell, I'll come and see you, Wardell.
Okay.
Thanks, Judge.
Thank you. Court does call the case, People versus Tanya Pawa.
Bob Dow, Assistant Prosecutor.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Pavak. Is that your name?
Tanya Pavak.
Your Honor, can we please set this for a final settlement conference?
Final settlement conference, June 5th, 2026 at 9 a.m. Jury selection, if necessary, June 8th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. On continue. Court calls case People versus Jackson Sturtevant.
Rob Dow, Assistant on behalf of the people.
Ron Brown appearing on behalf of Mr. Sturtevant, Your Honor. Please introduce yourself.
Jackson Sturtevant. Sorry. What are we doing?
Your Honor, I'm requesting an adjournment. We're trying to resolve the case without going to trial.
Turn the matter to next date. Oh, you need more than a week?
Is that enough time for you to think about it?
No.
How long you need? May 18th? Thank you.
Matter to May 18th, 2026, 9 a.m. or 1 p.m.
Thank you.
Thank you. Continue. Court calls case People versus Alan Anderson.
Ron Brown appearing on behalf of Mr. Anderson, but not with.
Alan Anderson.
He's not in custody, Your Honor.
Right. And the last time defendant was here, he admitted to the violations. And happened. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. Give a 10% privilege on that. The warrant will issue with you. Court calls case of the People versus Eric Buckner.
Ron Brown appearing on behalf of Mr. Buckner, Your Honor.
Buckner, can you state your name?
Eric Buckner. All right, Eric Buckner.
Teresa Blair on behalf of probation, Your Honor, Mr. Buckner is before the court for a review hearing. Mr. Buckner is in compliance with the court's order accepting his payment plan. $152. So I'll take the court, Mr. Buckner, he has that probation aware of his financial status. He was out of work for some time. He had some medical issues due to an injury with a dog bite.
Hold on just a second. Mr. Buckner, you'll need to turn back on your camera, please. Go ahead, Ms. Blair.
That the court, I think, was aware of. Mr. Buckner has began part-time employment. He's working at McDonald's, but it's only on a part-time basis. He did get fined on his bills and had his power off. That power has been turned back on. It was off for 3 or 4 days. Given all the circumstances at this time, probation is asking that Mr. Buckner pay that arrearage of $132 by May 29th. Then keep up with a payment plan of $66 per month, and then he continue with all other orders that was set by this court, with the next review hearing being set August 3rd, 2026 at 1 p.m.
All right.
No objection. If you don't have any, Mr. Buck. Your microphone's muted.
Mr. Buckner?
No, I don't have any objections.
All right. You'll be able to make that 132, get yourself back on track by the end of the month?
Yes, sir.
All right. Then I'll order the defendant paid $132 arrearage. He's to pay that by May 29, 2026, then $66 per month thereafter. Continue all terms as previously ordered. I'll set the next review hearing for August 3rd, 2026, 1 p.m. All right. Thank you, Mr. Buckner.
Thank you, sir. Have a good day.
You do the same. Court calls case of the people versus Darnett Blackwell.
Rob Dowd, prosecuting attorney on behalf of the people.
Ron Brown appearing on behalf of Mr. Blackwell, Your Honor.
Claire, on behalf of probation, Your Honor, Mr. Blackwell was scheduled before the court for a review hearing. He is chosen. Probation, ending all conditions. With the next review hearing being set August 3rd, 2026 at 1 p.m.
Not objections, so ordered.
No objection.
Court calls case people versus Robert Lewis Jones.
Rob Dowd, prosecuting.
Tracy Claire, on behalf of probation, Your Honor, Mr. Jones was scheduled before the court for a review hearing. He is compliant with the terms ordered by the court, and I did waive probation's recommended with the final review hearing being set August 31st, 2026 at 1 p.m.
Not objection, so ordered. Court calls the case people versus Juan Osorno.
Getting attorney on behalf of the people.
Ron Brown appearing on behalf of Mr. Osarno.
Claire, on behalf of probation, Your Honor, Mr. Osorno was scheduled before the he is compliant with the terms ordered by the court. I did waive hearing. Probation recommending that all conditions. The final review hearing will be set August 31st, 2000.
It was still warm. It wasn't long before, after you did what you did, that we was there. I have those tensions at my house now and a couple of his suits and clothes because that's all I have in memory of him in pictures. Russell, I met Russell 2 years before you murdered him. I didn't even know that. Yeah, your grandpa, that's my cousin. That's my first cousin. He was a good guy. I believe in second chances or whatever. He was a good guy. When I was on them crutches and had them 32 staples in my leg and couldn't walk, was non-weight bearing for 3 months. Russell came, checked on me, brought me food. Yeah, on like clockwork. He took care of me. Diane couldn't be here today. No, you know her. Yeah, I see how you looked at me when I said her name. She couldn't be here today. But she did write a statement, give it to the parole people. I hope they read it. But you've run my family. I think you deserve the max. I don't think there's no hope for you. Because you don't have any remorse. Of course, when people come to court, they're supposed to say what they have to say. But like I said, you were my first. I will never forget you. I had to go buy a hat. I went and bought my brother a tie, a shirt, a suit, underclothes, all that stuff I had to do. I didn't want to do that. I never buried nobody in my life. I was forced. I didn't want to have to do that. And to see it didn't have to put my own personal health at risk because I'm supposed to be non-weight bearing to go do the things that needed to be done when you bury somebody. Death certificate, going to the funeral home, coming to Ken down here to I think his name is Ken Paxton that's on the paperwork because my brother didn't have life insurance to get help with his funeral. Yeah, I think you should have to pay that $600 to $800 back. Yep. All that. I never had done that before. Get a death certificate, had to sign it. I had to do everything. Stuff that I didn't want to do, stuff that I never knew nothing about. Because of you. So, as far as I feel about you, like I said, I don't hate you. I hate what you did. You took away a son, a father, a family member. Lonnie didn't deserve that. He did. If Lonnie was a bad guy and was around, doing awful things, I wouldn't even be here. And God in heaven, no, I'm telling the truth. I wouldn't be here. I wouldn't back that up. But I knew my brother. And I knew the man that he was. He was a godly man. He was going to church. He was getting up and working every day. Like a citizen, paying tax. He didn't deserve it. My family didn't deserve it. I didn't deserve it. So what I have to say to you is that do your time like you did the crimes. You killed those people. You had no remorse when you did it. Honestly, I wish you wouldn't went to trial. Because I know when you go to trial, they play all the phone recordings and everything. And like I say, put on the smile. So all the phone calls you was making while you was in here and all that, I wish you wouldn't went to trial. I really wish. But we're here now. But yeah. I hope when you're in prison, I hope you do all your time day for day. I hope you stay healthy while you're in there. I hope you get up every morning, and I hope the people that you murdered hunt you. I hope you can't sleep like I couldn't. I've been to my doctor so many times. Never been on depression pills. I had to put cameras around my whole house is full of cameras. Every corner, the middle, the side. I have so many cameras now because of you. I didn't live that way. And I'm a boyfriend person. Because of you, you had me living in fear. Every time somebody would pass by and a camera would go off, even if it's a car, I'm looking out the window. You did that to me. You hurt me, you hurt my family, and you need to pay for what you did. Just like you did the crime, you need to do the time. And I still pray for you. Believe it or not, I pray for you. I pray that God heals your heart. I pray that God, whatever this sickness is that you have, I don't know if it's a sickness or if it's a desire, if it's something that you like to do, if it's something you get off on. I don't know what it is. I don't think it's a sickness. I think it's something you get off on. But I just pray and ask God that God really help you because you need it and you're going to need it. And these people up in here, everybody have a job to do. And everybody's doing their job. But there's only one God. He got a job to do too. And one thing about him, we can ask for forgiveness and he can forgive us. But we still have to be punished for what we done. And you need to be punished. You need to stay punished. You don't never need to get out. No family should ever have to come in here and do this. Ever. Ever. I don't know how long I'm gonna be messed up behind my brother. I miss my brother. I do. I miss him. And every time he comes to my mind, I always say, not now. Not now, Lonnie, because I don't want to cry. I just want to push it away. When I'm going to sleep, you think of everything hits you when you lay down. And here come Lonnie. I'm like, not now, Lonnie, I gotta sleep. So I just pray God have mercy on you. I hope you get the max. You deserve the max. And you don't need to be out where you can harm nobody else. Children, women, dogs, cats, singing, walking, and talking. Go do your time. Because we doing ours.
Hi, everybody doing? My name is Nikita Myers. I'm Reginald's cousin, and I'm Lonnie Scott's sister, the third to the oldest daughter that my mom have. And like my sister said, when my brother died and they brought him out in the black bag, we was all standing outside. The day after that, me and my sister go to the house. We clean blood off the walls. We clean blood off the floors. We clean his house, everything. I mean, it was gross. It's something I don't want nobody to witness. It's something I don't want nobody to go through. Like I said, it's my brother. I love him with all my heart. A lot of my family I don't know if they taking it to well. I'm still grieving because I feel like it's not true. That it ain't happening, and he's still here some kind of way. But I know he's not. And I don't know you. I don't know what you're going through. But I'm pretty sure if you had somebody that did the same thing to my brother and my cousin, they did to your family member, you'll feel the same way we feel. You need help. You really need help. And I don't know nobody that's going to sit up in this courtroom and take up for you and take your side when you kill two people. Then when you kill one man, you went back to go to the house after you killed him and then turn around and kill another man. That's cruel and unusual punishment. And you need to be punished. You need to be punished. You need to pay for whatever you did. And like I said, I don't know you from Adam. This is my first time seeing your face. I took off work just so I can look at you in your face and tell you whatever they give you, they need to give you. And I'm here because I want justice for my brother because he can't do it for himself because he's not here. That's why I'm here. I want justice for Lonnie Dean Scott. I want justice for Reginald, your grandpa. They need justice because you here, they not. You can leave here and go back in your cell. They here, they not here. You are. You can still live your day while they in their graveyard. We gotta go visit them in the graveyard. Whatever you guys give her, she deserves. She deserves. Don't show her no mercy if she didn't show them none. And I'm through.
And one more judge from the mother of the child who was previously under, there was a sentence. We waited until everything was sentenced before I came to speak. So
Go ahead, please.
How you doing?
Yes, ma'am.
I'm April Robinson, and I'm the mother of the child that she assaulted, her niece. I'm here today standing for my daughter, Lace's niece. My daughter trusted you. She sincerely loved you. And you betrayed her. You violated her in the worst way possible, ever. And as a mother, you also did it to me because you know how I am about my children. And I trusted you with my daughter. And you know how Leah feel about y'all. And you did her bad. You did her wrong. For years, you continuously assaulted my child when all she did was love you. That's the worst. You're the worst type of person. And although you did all those, and you couldn't even take accountability for what you did. You lied. You made her family, your family, turn on her. You know what they did to her? That her own people gonna turn their back on her for you when you know what you did to her? That's the worst. It's the worst. You can't even take accountability for what you did to your own niece, who you supposed to protect and love and make sure nobody else on the outside harm her. You harm her. You doing bad to her. But you know what? Even in spite of, God is good and he sits out and he looks low. My daughter is prospering. She's intelligent. She's doing wonders. Nothing you did to her is stopping anything they go out here and set for her to do. She's doing everything despite of what you did to her. And I prayed and I prayed and I prayed. And I'm here because I hope you sit in prison every day of your sentence and you suffer. You look like you're suffering right now. You can shake your head all you want, but I pray every day that you're in there, you sit and you suffer and you take what you did, not only to my daughter, but also the murders. That you sit there every day and you think about what you did and you take it off because you did that. Take accountability for what you did. And get that suffering that you put on my child, that you put on his family. And I'm gonna leave it at that because at the end of the day, God controls all of this. And I'm glad he gave you 40. That was my prayer. Thank you, Judge.
Anything else?
Okay.
In this case, then we're in recess. Thank you. Next, anything else? By anybody? Oh, on any other cases? No.
So it's still on the same
Are there any other matters from the state or defense to take out? No? Y'all don't have anything No, y'all were talking about something else. Okay.
Yes.
Then we are in recess. We'll be taking a jury here at 1:30. Thank you.